Quiet, please.
All right, back on the record in the Simpson matter. All parties are again present. Mr. Simpson is present with his counsel. Mr. Shapiro, Mr. Cochran,
Yes, good morning, Your Honor.
Mr. Spaulding, Mr. Bailey, Mr. Blazer, people represented by Ms. Clark and Ms. Lewis. Jury is not present. Anything we need to take up with regard to Ms. McKinney before we resume?
Yes, we do, Your Honor. I would ask Your Honor to listen to Dean Ullman with regard to the proposed jury instruction.
Well, jury instructions come at the end of the trial, don't they?
They normally do, Your Honor. However, this is a unique situation. I think Dean Ullman can explain it if you will allow it.
Your Honor, we have submitted a special proposed instruction that we would ask the court to give at the conclusion of Ms. McKinney's testimony. The genesis of this instruction is Section 412 of the California Evidence Code, which provides that if weaker and less satisfactory evidence is offered when it was within the power of the party to produce stronger and more satisfactory evidence, the evidence offered should be viewed with distrust. Our concern is that the jury may view the evidence with respect to the racial epithets in the tapes and transcripts with distrust, since they are not being given the opportunity to hear the stronger and more satisfactory evidence of seeing the transcripts themselves and actually hearing the tapes. So we believe it's appropriate under these circumstances for the court to inform the jury of the court's ruling and the reason why they are not being allowed to see the transcripts or hear the tapes. And we fashioned a jury instruction which actually uses the language of the court to explain to the jury why they will not have that opportunity. In very simple and non-judgmental language, they would be informed that they will not be allowed to see the transcripts or hear the tapes.
Do you know of any precedents for a jury instruction like this, do you know? You ever seen one like this before?
Well, yes, I believe that on occasion courts have instructed the jury in the language of Section 412. And in fact, we will submit an instruction because we believe the prosecution has presented weaker and less satisfactory evidence when stronger evidence was available. But that instruction should not be used against the defense in the context of a ruling of the court that precluded the use of stronger and more satisfactory evidence when the evidence would have been offered but for that ruling.
All right. Do you have any case law authority for this proposition?
I do not, Your Honor.
All right. I'll hear from the people.
This is a very obvious attempt to have the jury focus on what they haven't seen and haven't heard. It's like, don't think of the marshmallow man. That's all you can think about, and that's what this instruction says. Think about all you haven't heard. Think about all you haven't seen. And that's the intent of this instruction. It's highly inappropriate. It seeks to highlight what the court has deemed inadmissible. What's the purpose of having rulings under 352 that make evidence inadmissible if all you do is turn around and tell the jury, guess what? There's all kinds of stuff you haven't seen. What's the point? And then you have their imaginations run wild with what they haven't seen. It's bad enough that they know that there are, 14, 11, 12 hours of tape. They've heard 1 second. I think that they get the picture. And the 41 or 42 times, every time Mr. Cochran asks her the question, it becomes 42, 43. We're going to be up to 470 if he keeps questioning her. But they get the idea. They get the idea plenty. They've heard 2 excerpts. They know he said it 41 times. They know he spoke to her for 12 hours on tape. All of that gives the jury the clear view that they've gotten a small snippet. All this seeks to do is highlight this matter, inflame the jury more, and get them to think about how awful the rest of the 39 or 40 times were in which he uttered the word. It's so obviously inappropriate that I don't even think I need to argue this any further. With respect to whether Section 412 could form the appropriate basis of a jury instruction, I don't think I disagree with that. I think that the court could appropriately instruct. That is the evidence code, that is the law, and it's available to both sides. if Dean Ullman thinks that we are going to argue Section 412 with respect to this evidence, he is sadly mistaken.
Oh, I don't think that would ever happen.
It will
I don't
not.
think that's the import of his argument.
Oh, I think that's exactly what he said, that the people would argue this instruction against the defense to point up the fact that they could have offered better and stronger evidence, i.e. more inflammatory, but they failed to. And in point of fact, I can assure the court and counsel that will never occur, not with respect to the tapes. They've got his voice. I think that's pretty strong evidence that he said it. So this is nothing but an attempt to highlight the inflammatory material that has been ruled inadmissible, and to cause the jury to speculate on what they haven't heard and to imagine the worst, which I think, I don't know. It's already so inflammatory what they have heard, Your Honor. The defense has already gotten the benefit of the most prejudicial and inflammatory thing I think I've seen admitted in a court ever, you know, by virtue of what we have in Ms. McKinney's tapes. Now they want to have the jury speculate how much worse it gets. It's obviously improper.
All right, Stroman?
Your Honor, the instruction tells the jury not to speculate. It's precisely the opposite of what's just been represented to you. The instruction suggests the court tell the jury you should not speculate about why you have not had an opportunity to see the transcripts or to hear the tapes. We're not inviting speculation. What we're trying to avoid is speculation under an inference ordained by the evidence code, where the jury is invited to view the evidence with distrust because stronger and more satisfying evidence has not been presented. Our problem, of course, is that, as Your Honor concedes, the two excerpts that the jury has heard are among the most innocuous and least inflammatory of all of the evidence available. And Your Honor sustained an objection to Ms. McKinney's characterization of the evidence in that respect. We believe the jury should hear the reasons why Your Honor is keeping out those other 39 in the language that you used in your order. That your examination reveals that the epithet...
Counsel, you don't need to read my order to me. I know what it's there.
Well, we think it's appropriate for the jury to be informed of that order so they know why they're not hearing all 41 of these.
All right. Thank you, counsel. All right. I'll take the request for the instruction under submission for consideration at the time of the jury instruction conference. All right, Deputy McNair, let's have the jurors, please.
All right. May I just ask one question with regard to the question I asked Ms. McKinney yesterday? The court care to reconsider that, or whether or not I can ask her if she can characterize this, the one tape portion that was played as compared to the others?
No.
All right.
Thank you.
Thank you.
Let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, Ms. McKinney, would you resume the witness stand, please? All right, the record should reflect that Ms. Laura Hart McKinney is again on the witness stand undergoing direct examination by Mr. Cochran. Good morning again, Ms. McKinney.
Good morning, Your Honor.
Ms. McKinney, you're reminded that you were still under oath. Mr. Cochran, you may conclude your direct examination.
Good morning, ladies and gentlemen. Good morning, Ms. McKinney.
Good morning, Mr. Cochran.
When we concluded our day yesterday, we had played a tape for the jury. You'd shared with us that you identified for this jury that was Mark Furman's voice. You recall that?
Yes.
And with regard to the tapes, the 12 hours plus tapes and the transcripts we talked about yesterday, did you turn those tapes and transcripts over to the prosecution just as you did to the defense in this case?
Yes, I did.
And have you been interviewed and talked with the prosecution and cooperated with them?
Yes, certainly.
And you are out here from North Carolina pursuant to a subpoena, is that correct?
That's correct.
And you tried to cooperate with both sides?
Yes.
Now, with regard to these tapes and transcripts that we've been talking about, after the first interview that you had with Mr. Detective Furman in February of 1985 that you described for us, I showed you yesterday a series of questions which you sent to him prior to the second interview, is that correct?
That's correct.
And that second interview would have been in April of 1985, is that correct?
Correct.
Along with the questions that you sent him, did you send him a transcription of the tape of an earlier meeting or any transcription? Do you recall?
I sent him the transcription of our April 2nd, 1985 meeting, our first taped interview.
All right, and you sent that to him, and did he ever, as far as you know, make any changes at all on that transcription that you sent him?
No.
Now, later in 1985, did you have occasion to prepare a series of transcripts that you had prepared from the various tapes you'd conducted and send those to Mr. Furman?
Yes.
Will you tell the jury when that was, ma'am?
That was sometime in mid-June. I don't remember the exact date, but at that time I compiled all of the transcripts from our interviews and put them in a 3-ring binder with indexes and dates similar to the way I was logging the transcripts and keeping them for myself.
And did you give those to him or mail those to him, or what did you do in that connection?
I gave those to him in the binder.
Did you ever at any point get any of those, the transcripts that were in the binder, back from him with any changes?
No.
And so that we're clear about what was inside the binder, it contained some hours of the transcriptions of the tapes you'd had with this particular individual. Is that right?
That's right.
Did he ever give back the bound volume to you?
No.
So as far as you know, he still has it. Is that correct? Well, as far as you know, he still has it, right?
As far as I know.
Now, yesterday we talked about Mr. Furman's role as a technical advisor or a consultant. Was he to be paid if the screenplay was ever sold by you?
Yes.
And what was that compensation to be?
$10,000.
Has that screenplay been sold?
No.
And with regard to these tapes or interviews that we call interviews of Mark Furman, you have not tried to sell those tapes yourself, have you?
They're not for sale, no.
You're not trying to profit from those tapes, are you?
No.
Now, with regard to the references of the so-called N-word that we talked about, we talked yesterday, and I think the two examples that we were able to play for the jury, I think you said it occurred maybe in April of 1985. Is that correct? The two examples occurred in 1985?
Yes.
And do you recall the first one about where he grew up? When was that?
That was during our,
Haven't we covered this already?
Perhaps so, Your Honor. It's leading to another question, Your Honor.
All right.
Thank you. When was that?
that was during our first interview.
All right. And the
April
second one,
2nd.
I'm sorry, the second one was also in 85?
Yes.
All right. The use of this word by this man, however, continued through 1988. Isn't that correct?
Objection.
It's leading. Leading.
Oh, thank you. Let me ask you another way. Thank you. Were there times after 1985, in the course of these interviews that you had with Mr. Furman, that he continued to use this word?
Yes.
And how long did it continue to go on? Oh, you may answer.
In the transcripts through 1988.
All right, thank you. Now, I think you've already explained to us that the last interview was in July of 1994.
That's correct.
After this case had occurred, is that correct?
Correct.
Now, with regard to yesterday, just briefly, we talked about the fact that you'd inadvertently taped over the first tape and also maybe number 9. Is that correct?
Correct.
The transcripts that we talked about, had the transcripts been made before the tapes were inadvertently taped over?
Yes.
Right. So you completed your process of doing the transcripts before you then taped over the actual tapes. Is that correct?
That's correct.
Now, in these interviews that you conducted with Mr. Furman, did you ever at any time ask him to embellish or enhance what he was telling you?
Objection.
Oh.
No.
In fact, what did you tell him in that regard, if anything? Oh.
I told him that I wanted realistic scenarios and responses to what may happen relative to the development of the story and characters.
And in talking to you, did he relate his own personal experiences as a police officer?
Objection.
Sustained.
Well, in talking to you, can you describe what he did with regard to his personal experiences as a
Objection.
police officer?
Sustained.
You were talking to this man because he was a police officer, isn't that correct?
That's correct.
And why did you want to talk to him?
Objection. That has been answered.
Has been.
All right. In addition to talking to Mark Furman, did you talk to other police officers in and around this same time?
Yes, I did. Approximately 15.
15 police officers?
Yes.
Did you go to the police academy?
Yes, I went to the Los Angeles Police Academy and talked with physical training people who worked with cadet patrol women there. And I went on ride-alongs and talked with other police officers as well.
And why did you do these things?
It was important to balance my understanding of the frustrations, as I mentioned before, that the women were feeling, the reasons why they wanted to become officers, and some of the obstacles that they faced, the very real obstacles that they faced on the force, and with dealing with some men who might belong to a group, Men Against Women, who didn't want them to be officers. I needed to have a clear understanding of the realistic kinds of obstacles they would face.
All right. Now, we mentioned that these N-word references were between 85 and 88. Did you have any interviews with this man between 88 and 94 that were taped?
Yes.
And how many? If you recall.
Between 4 and 6.
All right, there were less than had been before in 85 and 86 and 87 and 88.
Again, please.
Where the frequency of the interviews, did they become less after about 1988?
Yes, they did.
And was there a period of time when there were no interviews, a year or so when there were no interviews?
No taped interviews,
No
that's
taped
correct.
interviews? And when was that?
During the early 90s, there were few taped interviews.
All right. Now, yesterday you had shared with us and with this jury that when Detective Furman used this word, this offensive word, the N-word, he seemed to speak in an ordinary speech or something of that nature. Do you recall that?
Yes.
And would you describe for the jury what you meant by that?
Objection. That's been answered.
No.
Sustained. Sustained. Was asked yesterday.
To explain it, Your Honor?
Yes.
All right. May I just second your? Thank you. Your Honor, nothing further at this point.
Mr. Darden?
Good morning, Mr. Darden.
It is true that you and I have met before, correct?
That's true, yes.
You, your husband, your attorneys, Ms. Clark, Ms. Lewis, Mr. Hodgman, and myself, we all met on August 17, I believe, in the DA's office. Is that correct?
Yes, I believe that was the date.
Okay. It's August 17, 1995.
Yes.
Okay. And we had a discussion about the transcripts and tapes and epithets that you described here today and yesterday, right?
Yes.
Okay. And it is a fact, isn't it? That is that Mark Furman used these epithets in 1985, correct?
Yes.
And in 1988, correct?
Yes.
Now, the two gentlemen seated here behind me, who are these two gentlemen?
Mr. Ron Regwan, Mr. Matthew Schwartz, they're my attorneys.
Okay. And they are entertainment attorneys?
Check down, this is relevant material.
Sustain.
You told us a little while ago that the tapes and transcripts were not for sale. Is that correct?
That's correct.
Just a moment, six,
Oh. May we ask that
I think she answered the question.
they are entertainment lawyers?
Objection, Your Honor. Stand, please.
Sustain.
Isn't it true that Mr. Redwine and Mr. Schwartz have been attempting to sell those transcripts and those tapes?
Objection, Your Honor.
Just-
Certified privilege.
Overruled.
I'm objecting, Your Honor, also.
Overruled.
I can answer the question?
You can answer the question.
The question is, isn't it true that they have been attempting to sell those tapes and transcripts?
Yes.
Yes. No, that's not true.
Okay. I'd like to show you. May I have a moment to confer with counsel?
Yes.
Have you been attempting to sell any audio tapes other than the Furman audio tapes?
No.
Okay. Have you been attempting to sell any transcripts other than the transcripts of the Furman audio tapes?
That question is vague to me. Could you rephrase it? It makes it sound like I'm attempting to sell the tapes and transcripts, and I'm not. So I'd appreciate it if you'd rephrase it.
What's next in order?
I'm sorry. 603? People 603.
I have a 4-page document. It's dated August 18, 1995. It is entitled Non-Disclosure Agreement. It is on the letterhead of Regwan and Schwartz in their law offices. May I approach the witness, Sean?
You may.
And may I remain for a few moments?
Yes, you may.
Let me show you what has been marked. People 603, please. You can take it. Is that document entitled Non-Disclosure Agreement?
Yes.
Is it on your attorney's letterhead?
Yes, it is.
Is it dated August 18, 1995?
That's correct.
And you are their client?
I am.
And paragraph 2 in that document, does it read as follows?
Object from the foundation with regard to this witness and this document.
Sustained.
That document is addressed to Dove Publishing, is that correct?
That's correct.
To the publisher himself, Mr. Veener?
I don't know that he's the publisher. It's addressed to Mr. Michael Veener, yes.
Were the tapes, Furman tapes, submitted to Michael Veener at Dove Publishing?
No, they were not.
Was there an attempt to submit them to him?
Not to my knowledge, no.
Okay. Look at the last page of that document, if you will. Is there a signature at the last page?
Yes, there is.
Okay. And can you read that signature?
It's Ron Regwan.
Now, if you could turn back to the first page, please. Does the document contain the term?
Object. There's no foundation.
Sustained. Sustained. Foundation.
Have you ever spoken with Inside Edition?
Have I ever spoken with Inside Edition?
Yes.
Could you define what Inside Edition is? Is that a tabloid or television show, newspaper, periodical?
Okay. You're not familiar with the term Inside Edition?
I've heard the term, yes. I've heard.
Wait. Oh,
I have heard Inside Edition, but I would like you to define it for me, please, so I'm clear in my response.
Okay. It is a television program. Have you ever spoken to any representative from Inside Edition, the television program?
No, I have not.
When did you bring those tapes to California? Recall the date?
When we were subpoenaed, we flew to California on July 13th, 1995, and my husband and I brought the tapes and gave them to the court.
Now, the document in your hand, you've never seen that document?
No,
Did you authorize your attorneys to sell the transcript?
no,
Did you authorize them to sell the audio tapes?
no,
Have you ever discussed with anyone selling the audio tapes for $500,000?
Have I discussed that with anyone?
Yes.
No, I have not discussed it with anyone.
Have you given your attorneys the authority to negotiate for the sale of the Furman tapes?
I've authorized my attorneys to determine the value of the tapes. Yes.
Okay. And is that what that document relates to then?
Object.
whoa. You can ask the question.
Thank you. I would assume, although I have never seen this document, that that's what this relates to. It's a non-disclosure agreement.
Doesn't the document say that the tapes are submitted so that Dove Publishing can decide whether or not they want to purchase?
Sustain. Sustain.
The witness.
Sustain.
Is it indicated anywhere on that document that the tapes are being submitted to Dove Publishing so that Dove Publishing can help you ascertain the market value of the Furman tapes?
Never seen it done.
Would you ask the question again, please?
Where, if anywhere, on that document does it indicate that the Furman tapes are being submitted to a publisher so that the publisher can help you determine the market value of those tapes?
I object to that question. Sorry, man.
Firstly, I have never read this document. I've never seen it. I would have to read it to be able to answer that question clearly. And the tapes and transcripts were never submitted to Dove Publishing. They have only been given to the prosecution and the defense.
If you weren't interested in selling the tapes, why then did you meet and confer with others
Object.
to determine the market value of the tapes?
Object. Stay.
Again, please, then?
The question is this: if you weren't interested in selling those tapes and transcripts, why then did you have your attorneys go out and attempt to submit them to publishers to determine the market value?
Sustain.
The document.
Sustain. Rephrase the question.
If you weren't interested in selling the tapes, why did you have your attorneys contact a publisher?
It's important to know what the value of the tapes are. And I authorized my attorneys to do that.
And that's because you were considering selling the tapes at the time?
No, I wanted to know what the value of the tapes were, and my attorneys advised me that it was in my best interest and they would be negligent as attorneys if they didn't let me know exactly what the value, market value of the tapes or the transcripts would be. Keep in mind, I've had a great deal of material leaked, and that's an aspect that I would certainly want to be considering.
In addition to attempting to determine the market value of the tapes, you also had your attorneys attempt to determine the market value of your transcripts of the tapes as well. Is that correct?
That would be correct, yes. I thought that's what this document was in reference to, certain transcripts I believe you have highlighted in yellow.
Was it your testimony yesterday that you were offended when you heard Mark Furman use that epithet?
Yes.
Now, when you met with Ms. Clark and Ms. Lewis and Mr. Hodgman and myself on August 17, do you recall me asking you what you thought or what came to mind when you first heard Furman use that epithet?
Yes, I do.
And you told me that nothing came to mind. Is that correct?
That's correct. But I couldn't remember anything coming to mind the first time. Your question was what came to mind the first time you heard that word, I believe.
But you couldn't remember what came to mind at the time.
No, that would have been about 10 years ago. I could not remember the first time I heard that word used, what came to my mind.
You couldn't remember a white police officer using this epithet in your presence and you're not being offended by it?
Objection to the form of that question.
Sustains argument. Argumentative.
You understand that that word is the most vile word in the English language?
I think it's one of the most vile words in the English language, yes.
You think they're worse?
Yes, I certainly do. Why are we having this adversarial relationship? I don't understand that. It's a vile word. Why do I have to define it more so than it is?
You wrote a screenplay, right?
That's accurate.
Did you use that word in the screenplay?
Yes,
Did you attempt to go out and sell that screenplay?
certainly.
You're using that word in your screenplay to help make money, right?
Yeah, on that question.
Sustaining it. Sustain.
Are you trying to make money off of the use of that word?
Check, on this question.
Overruled.
Check.
Overruled. It's an appropriate question.
When you met Detective Furman, you told him that you were a screenwriter,
That's accurate.
and you told him that you had written other screenplays.
Yes.
And how many screenplays have you written up to this point?
I've written about a dozen screenplays, approximately 6 that I would consider that would be in appropriate shape now to be read, but I've written about a dozen screenplays, more treatments, synopses.
And how many screenplays did you tell Furman you had written when you first met him?
As soon as the back nine is, she told me.
Sustain.
Did you tell Detective Furman how many screenplays you had written when you first met him?
I don't recall telling him how many screenplays I had written, but it could have come up in conversation that I had the year before won an award for a screenplay through the Writers Guild of America East Foundation. That could have come up.
Do you have to be a member of the Writers Guild to win that award?
No, you don't.
Are you a member of the Writers Guild?
No, I'm not.
You've had one screenplay published or made into a film?
Have I had one screenplay made into a film?
Yes.
No.
Have you had any made into a film?
I've had short pieces filmed, yes.
Okay. You had a short piece called The Painter?
Yes, I did.
Okay. And who made that into a film?
That was produced by Playboy Productions.
And who directed that film?
Daniel McKinney.
Your husband?
That's correct.
And this piece was what, a sort of soft porn kind of a piece?
Sustain. This is not relevant. This is not relevant.
When Mark Furman used these words in your presence, why didn't you just tell him to stop?
All right, check. That question. Check your phone.
Overruled.
Back nine.
Overruled.
For the same reason, I didn't tell him to stop when he told me of police procedures, cover-ups, other information that I felt were important for me to have a clear understanding and context of this material that I was writing. He told me many things that I thought were important for me to understand, many things I hadn't been aware of, as did other officers of the Los Angeles Police Department, as did many of the other interviews that I did and ride-alongs I went on. I was in a journalistic mode. I was not judgmental, and I needed that information to help me write a more realistic journalistic piece. And I did not ask him to stop using the type of normal, ordinary language he would use or other officers would use. I needed to know how he would speak.
You told us yesterday that there was no racial subplot to the screenplay you were planning to write, correct?
And that's accurate.
And yet you use this epithet in your screenplay anyway. Is that also correct?
That's true.
Now, your relationship in 1985 with Mark Furman, was it only professional?
Check, yes. Oh, chair.
Overruled.
It was a it was a business relationship. He was the technical advisor for the screenplay.
And that is it?
Yes.
About cover-ups a few minutes ago. Is that right?
I'm sorry, again, please.
Did you mention the term cover-up a few minutes ago?
I did, yes.
And what you were alluding to at that time was a discussion you and Furman had as it related to women police officers. Is that correct?
Got objection on checking the phone of that question.
Is that correct?
Again, please. I'm sorry.
And what you were alluding to was a conversation you had with Detective Furman as it related to female police officers and the LAPD's recognition that female police officers did not perform well in violent situations. Is that right?
Object before that question.
Some LAPD officers, and also in relation to police procedural cover-up issues that I needed to know about.
You spoke to us on August 17. Can I have one moment? When I look for this, strike that. To bring Mr. Cochran a clean copy of this document, Your Honor.
Why don't you show it to him? You recall during our August 17 interview that Ms. Clark asked you specifically what you meant when you used the term cover-ups?
Object before that, Your Honor.
Yeah, I do. Yes, I do remember us discussing that.
Okay, and do you recall her, strike that, and do you recall telling her that what you were referring to were cover-ups in terms of the LAPD's recognition and cover-up of the fact that female officers did not perform well in violent situations, or words to that effect?
I don't know if it was Miss Clark or Miss Lewis who made that comment. It was one of them.
Okay, but that was basically your response to them at the time?
Yes.
Okay. Now, you asked a moment ago why we're involved in some adversarial relationship. Do you recall asking that?
I felt that you were. I don't feel adversarial towards you, but I felt that there was something negative coming from some of your questions. Yes.
Okay. You didn't stop him the first time he used the epithet, correct?
It has.
Okay. Well, you didn't stop him the 20th time he used the epithet,
That has not. Overruled.
correct?
That's correct.
And you didn't ask him the 40th or 42nd time that he used the epithet, correct?
I didn't abridge his dialogue or conversation during an interview. No.
Given the fact that you've included this epithet in your screenplay, do you feel that it's appropriate under some circumstances to utter or use this word?
Object on this.
Overruled.
On that question.
Overruled.
Do I personally feel it's appropriate?
Yes.
No, I don't.
Why then include it in a screenplay that you intend to make into a movie?
Because it's reflective of a particular officer's or officers' dialogue, feelings at a particular time. It's representative of what would be said.
That's all I had.
Mr. Cochran?
Ms. McKinney,
Yes.
you don't like racism, do you?
No.
But you understand that racism exists in the world. Are you aware of that?
Yes, I'm aware of that.
And the fact,
Excuse me, these are argumentative and leading. Proceed.
the fact that Mark Furman used the N-word more than 42 times.
Overruled.
That make you agree with him when he's using those words? Did you agree with him when he was using those words in that base, vile manner?
Of course not.
You described for us that you were working as a journalist at the time. Is that correct?
That's true.
And with regard to your screenplay, Men Against Women, you told us yesterday that racism was not not even a subplot. Is that correct?
Oral.
Is that correct?
That's true.
And so when these words, these vile, insulting words came up, you weren't saying these words, were you?
No.
Who was saying these words?
Officer Furman.
Who was expressing these views of cover-ups?
Officer Furman.
And with regard to this cover-up,
Oral.
with regard to cover-up, he talked to you, did he not, about...
Sustain. Sustain.
Well,
Sustain.
Well, Your Honor, it need to be heard.
Sidebar.
Certainly do.
Step back from the jury room, please. All right, back on the record in the Simpson matter. All parties are again present. Jury is not present. Mr. Cochran, did you want to make any further comment on your...
Would the court allow Dean Ullman to make that for this point?
We're in mid-sentence in your argument, counsel.
But I would ask that you make, because it ties in with,
No, I prefer that you conclude the... Sir. What, Mr. Darden? Yes. Mine is not time-stamped on the side. Mr. Cochran.
Thank you very kindly, Your Honor, for this opportunity. What I wanted to indicate to the court, and I'll do it as briefly as possible, is that I believe that my colleague, Mr. Darden, opened the door when the testimony was elicited about a cover-up. Further, I think you have to, first of all, look at the thrust of their cross-examination. The impression they gave to this jury was that Ms. McKinney was in some way trying to profit from these tapes, profit from the transcripts, and nothing could be further from the truth. I need hardly remind this court that we got Your Honor to issue a subpoena, that I went to North Carolina, and we were rebuffed at the Superior Court, or the comparable court to the Superior Court. We had to go all the way to the North Carolina Court of Appeals, and these lawyers, Messrs. Regwan and Swartz, did an excellent job in fighting us to get this. She resisted coming to California. When she finally got here August 13th, you saw the problems we had even getting the tapes then.
No, I'm familiar with the history. Is that where you're going with this?
Well, yeah. I think they've opened the door clearly to that. But in addition, other than that, Your Honor, in addition to that, so that's the impression they give to this jury. She doesn't want to be out here. She didn't favor one side or the other. You'll recall that when we were in court that day, I'll get to the point, Mr. Simpson. You'll recall. Usually, I'm sitting next to them when we talk about that.
I know I can hear most of it.
You will recall that when we argued about the tapes belonging to the defense, or at least we had the right to it, she went down that same day, she and her lawyers, and gave a copy to the prosecution. She went in and talked to them. They interviewed her for hours. And that's why she was so taken aback by what she perceived as negativity. Now, with regard to what they've done here, you last week, Your Honor, and I know you don't like to ever be quoted, but this is time I think I can quote you appropriately, that you had said last week that it was clear to you that after listening to the tapes, it was clear that Furman wasn't describing a fictional character, but was describing his point of view. And I mean, everybody in the world knows that. Now, if that's true, these tapes are the best evidence. What they're trying to make it seem like she's trying to embellish this, that she gets these things out with Michael Wiener. A non-disclosure agreement is to test the water. Wiener or his office never, ever saw these tapes or transcripts. That should be abundantly clear. I can bring that out also. The lawyers felt it was malpractice not to know the overall value of these things. Now,
all right, Mr. Cochran, let me just cut to the chase here. The issue that I was concerned, I agree with you that it's probably appropriate redirect to go back and discuss the procedural fight to get those tapes, and that Ms. McKinney resisted all the way to the appellate courts in North Carolina, and that once she was compelled to come here to the state of California, then she cooperated with both sides. I don't have a problem with that.
Right.
I could probably do that in 5 questions.
okay, well,
All right.
we'll see if we
Second
can do
issue,
that.
the issue about selling the tapes, or I'm sure Ms. McKinney's had the opportunity to discuss with her lawyers the fact that the tapes and transcripts were never transmitted to Dove Audio to anybody else for commercial exploitation purposes. That's fair game because that's an issue that was brought up. I'm more concerned about the issue that was our last sidebar.
Let me address that, Your Honor. I think that clearly, when Mr. Darden got the answer about a cover-up of cover-ups, he then went back, as he indicated, to try and repair the damage, in his own words. And what he did was try to elicit from her, well, you were just talking about, when you talked about cover-up, that the LAPD covering up men against women and that sort of thing. That's not correct at all. And this witness will say as an offer of proof that, first of all, there were many cover-ups, as you know from the tapes. There were cover-ups from the very beginning when officers would go out and they didn't have probable cause to arrest anybody and tear up their driver's license. There's cover-ups and manufacturing evidence all throughout. But specifically with regard to men against women, in the instance, you recall...
I think that my recollection of Ms. McKinney's transcripts is when she talks about cover-ups, she talked about it in terms of, she used the term cover-up in the terms of a incident of police misconduct having occurred, and then there being a concerted effort by the officer involved to make sure that nobody was disciplined. For example, my recollection of the plot was that one of the female officers was supposed to have arrested somebody, then the transporting officers then beat the arrestee out of her presence.
Ruptured the spleen.
Ruptures the spleen with the batons. And then she comes in and says, I didn't see any of that. I don't know who transported, et cetera, and becomes part of it. That was my understanding of her discussion of cover-ups.
Right. Well, you're right on with regard to that. It's much more than what he's elicited, and clearly he's opened the door on that. It's about a cover-up where, to be one of the boys, this female then covers up the death of a suspect whom she's choked out, but she doesn't kill the suspect. The suspect is killed by these other male officers who beat this person to death by rupturing spleen. Actually, and that's not fictional, by the way, as this community is going to find out. The other issue, Your Honor, is this: that she talks about other cover-ups also. I mean, she talks about cover-ups all the way through. So what I'm saying, you can't just limit it to this instance of the men against women situation. They opened the door.
Which hence brings me to my question, where are you going? What specific instances are you going to?
I'd like to ask her, well, let me tell you the question I'd like to ask then, Your Honor, specifically. I'd like to ask her, what did you mean when you said cover-up? And I think she will then tell you what she means in the men against women context, but also in the other context where Detective Furman talked about covering up, and the court can ask her. I mean, I'm not testifying. She'd be the one so indicating, and I think we're permitted to do it. After that, and the final thing I'll say on this was, I think they've opened the door by virtue of the fact that this attack on this witness, this unnecessary, needless attack, and you told them about not going into this, and yet they did it. When they did that, they've opened the door to these tapes, and I think now we get a chance to do that. Now, you know, for instance, Mr. Darden's questions about as though she was egging Furman on, using racial epithets, or you didn't try to stop him, or whatever. That's almost as though you would say that when they wrote Roots, and they used the N-word in Roots, that you couldn't talk about racism. Judge, this play is about sexism. This lady is opposed to sexism. And in literary circles, in art, that's how you address things. So people start to discuss it and maybe bring about some changes. I mean, you don't buy into it necessarily. And so now that's been done. This door has been opened. It seems to me that we should be permitted to do this. And that's why... I wanted to make this statement to the court. Certainly you cleared the first part of it, but I think the rest of it is also clear, Your Honor. I'm being handed something. May I read something to the court my counsel just shared with me, Your Honor? This has to do with, let me just read this, and I think it puts it in perspective about lying and covering up. This was our number 10, describing the necessity for police officers to be willing to lie. Well, I really love being a policeman. When I can be a policeman. It's like my partner now. He's so hung up with the rules and stuff. I get pissed.
He's got more morals than he's got hair. I
remember that. You just don't fucking even understand. The job is not rules. This is a feeling. Fuck the rules. We'll make them up later. He's a college graduate, as you know, a Catholic college, etc. He was going to be a priest, etc. And he's got more morals than he's got hair. What do you mean he's got more morals? He doesn't know how to be a policeman. Whispers. I can't lie. Oh, you make me fucking sick to my guts. You know. you do what you have to do to put these fucking assholes in jail. If you don't, you fucking get out of the fucking game. He just wants to be one of the boys, doesn't want to pay the dues. So how does he deal with it? He doesn't lie. Well, I know for a fact in this internal affairs investigation, he has a 10-day suspension. He'll roll. He goes on to say, he'll drop a dime on me, he'll squeal. Now, Judge, that is cover-up. And that's another cover-up. And clearly, I think you understand that. And that's the point that we're trying to make. We are now permitted to at least play this to the jury, to at least ask questions about it. He can't talk about cover-ups and then try to put it in this little tiny frame that he was only talking about men against women, because that's not even clear. We can clear that up, plus show, I think, is a representation for this court that there are other instances of cover-up. And they opened the door. You ruled. We all understood that. But they've opened the door, Judge. So I'm asking you to allow us to do this, and let's get it on with. We can finish our case. They've opened the door. And also, you know, one of the other issues that we're going to be talking about is cover-ups raid probable cause, lying to try and put together probable cause. But that's another issue. But I think that this is a very germane thing. We sat over there. It's now happened, and it seems to me we should be permitted to do this, Judge.
Mr. Darden.
Your Honor, at 10:14, 44 seconds, I asked this question. When Mark Furman used these words in your presence, why didn't you just tell him to stop? Okay. And after an objection, Ms. McKinney volunteered for the same reason I didn't tell him to stop when he told me of police procedures, cover-ups, and other information, and so on and so on. So I didn't invite this witness to bring the term cover-ups into these proceedings or into her testimony, Judge. I asked her about a specific word. We're talking about a specific epithet, but she brought it in. And yes, I did attempt to repair some of the damage. And so now the issue before the court is, now that the witness has volunteered this, does that now allow counsel? And by the way, Ms. McKinney is his witness, not the prosecution's witness. Does that now allow counsel to drag in more inflammatory and irrelevant material before this jury? I don't think so. I don't think that's fair. I don't think it has any probative value at all. And what I was attempting to show the witness was an excerpt from a transcript of a conversation she and I had on August 17 in my office. And if I could just read into the record briefly what that excerpt says. And this is Ms. McKinney at page 5, line 19. He expressed very strongly that it would be wonderful if someone would write a story from his point of view, from the men's point of view, about why women weren't succeeding in those areas and what they couldn't do, and what kind of cover-ups were occurring in terms of that. And that interested me. Okay. So even my subsequent follow-up questions were directed to Mark Furman's belief that the department was covering up the fact that female officers did not perform well in violent situations. Okay, I wasn't getting into all this other stuff, and Mark Furman did discuss other kinds of cover-ups and other issues like that in his taped interviews with Ms. McKinney, and I concede that, and we've conceded all of this all along. But my point today is this. It's a personal point of view. At any event, I don't think this opens the door to any of this. I think it's time to take control, again, of these proceedings, and let's move along with the issues that are relevant.
May I respond, Your Honor? Your Honor, certainly, Your Honor, thank you. This, Your Honor, is about their attack on her credibility. And the court has said many times, been very concerned many times about leaving an unfair, a misleading impression upon this jury. You told the prosecution last week how they should conduct this cross-examination. What Mr. Darden did was he asked the famous why question.
I offered them some advice.
Well, yeah, I didn't mean in a
As I oftentimes offer you
both
advice.
sides, yes. But you made a suggestion. They didn't follow it. They asked the why question. That this answer that he got, and then he went into it further in cover-up. And when he does that, there's much more to it than that, and it's wrong. And they attacked her credibility, Judge, and you've heard those tapes, and that's unfair. That's a misleading impression to this jury. And they're using your ruling as a shield. They're turning the shield as a sword against us and against Mr. Simpson specifically. And so that's not right, Your Honor. We have a right, it seems to me, under these circumstances, to plumb this area, to bring out what you deem appropriate in this area. And we're not going to belabor it, but we have an absolute right. They opened the door. I mean, this isn't anything we did. We did our examination, sat down. We're back up here now because of something they did, and I think we have a right to do that. In the interest of justice and truth, we have a right to do that. Also, in the interest of a lady who fought getting out here, to malign her in front of this jury and give that wrong impression is not right. And so I think the court would want to at least allow us to straighten that out on each of these areas and to point out there's more to this cover-up regarding men against women, but also there are other cover-ups that she was talking about. And I think when you ask why questions, you get those answers, Your Honor, and that's the thing. That's the point that comes about. And I think that the record is very clear in this regard, and I ask the court to rule and allow us to do it. And you said 5 questions in there. We'll be very quick. I'll try to do the whole thing in 10 or 15 questions. In fact, I'll take your advice if you want to give me some on that.
All right, thank you, counsel. All right, as to the questioning regarding the procedural history as to how the tapes and transcripts got to California, and the fact that Ms. McKinney did resist through the appellate courts in the North Carolina courts, that is an appropriate line of questioning. As to the discussions regarding Dove Audio and the nature of that agreement, that is appropriate redirect examination based upon the cross-examination. As to the mention of cover-ups, the problem I have here is that the answer where Ms. McKinney mentions cover-ups was a non-responsive answer. The question was concerning tolerating the use of the N-word, or at least not mentioning it in response to the use, not making any mention in response to the use, and then adding gratuitously the issue regarding cover-ups. However, it is raised in the context of a specific statement by Ms. McKinney made to the district attorneys. That statement has been made available to the defense. Mr. Cochran, you may redirect your examination as to that statement made to the district attorney's office. All right, but that is the limitation.
All right, and so that I'm clear, I can plumb that particular area as to what you meant by cover-up in that area. Is that right?
That particular area about men against women, inadequacies of women police officers.
All right.
Alleged. All right, let's have the jury, please. All right, the record should reflect that we've been rejoined by all the members of our jury panel. And Mr. Cochran, you may continue with your redirect examination.
Thank you very kindly, Your Honor. Morning again, ladies and gentlemen. Good morning, Ms. McKinney.
Good morning,
might
Mr.
continue
Cochran.
on. Ms. McKinney, you had shared with us, in fact, I think on cross-examination, you said that you've been out here since July 13th. Was that correct? Was it July 13th?
No, it wasn't correct.
What's the correct date?
August 13th.
It may just seem like July 13th. Is that it? But you've been here since August 13th?
It's been a long time.
All right. And is your family here with you?
Yes, my husband and boys are here.
Now, ma'am, with regard to your coming to California, did you voluntarily come out here and bring your tapes and transcripts out here so you could come to California and testify?
No, sir, I was subpoenaed by the court.
All right. And when you were subpoenaed by a subpoena issued by Judge Ito in this court, did you resist and fight that subpoena?
Yes, I did.
And tell the court and jury what you did to fight that subpoena.
I hired Mr. Regwan and Mr. Schwartz, and they...
Two gentlemen seated there,
Two
ma'am?
gentlemen seated there, and they flew to North Carolina and fought the subpoena in court there with Mr. Cochran and Mr. Bailey.
So in other words, you first met me in North Carolina about a month ago, is that right?
That's correct.
And you fought this subpoena at that time, isn't that correct? Winston-Salem, North Carolina?
Yes,
In fact, you won in the initial hearing, isn't that correct?
my attorneys did, as well as the local firm with whom they were working.
All right, and thereafter,
Mr. Carmen, I think there's an impression here. You said that you were in North Carolina. I think needs to be made clear to the jury that you were on one side, and Mr. Rigwan and Mr. Schwartz were on the other side.
Yes, Your Honor.
At that time.
Thank you, Rick. When we were in Winston-Salem, North Carolina, on Friday morning, you had your two fine lawyers, Mrs. Regwan and Schwartz, right?
That's correct.
Plus local counsel there in Winston-Salem,
Yes.
right? And on the other side was myself, Mr. Bailey, and our local North Carolina counsel. Is that correct?
That's correct.
All right. And then at that point, the judge in North Carolina ruled for you, so you wouldn't have to come to California. Isn't that right?
That's correct.
And then we continued to fight this matter, and it went up to the North Carolina Court of Appeals. Isn't that right?
That's right.
And that's where we won at that point. Is that right? By we, I mean Mr. Simpson's side won at that point.
That's correct.
And I presume nobody was reimbursing you for the money you were spending. Lawyers aren't free, are they?
Objection, irrelevant.
Well, nobody was, in other words, nobody was helping you pay for these lawyers you had back there, were you?
No,
And at some point, when the North Carolina Court of Appeals upheld Judge Ito's subpoena, you then agreed to come to California. Is that correct?
I don't believe I had a choice. Certainly I would.
Right. And it was when the final court ruled, you then came to California. Is that
Yes.
right? And that was only after then when you produced and delivered these tapes. Is that correct?
That's correct.
All right. And once you came to California with these tapes and these transcripts, the same date that you delivered them to the defense, Mr. Simpson, you also delivered them to the prosecution on that same day, did you not?
That's correct.
And you tried to cooperate with them, didn't you?
I've wanted to cooperate with the court, the prosecution, and the defense, yes.
In fact, Mr. Darden asked you that if you came to California on August 13th, was it August 17th, as he asked, that you came down in this building in the DA's office and met with all the DAs and talked to them, isn't that right?
That's right.
And in that meeting, they tape recorded everything you had to say, didn't they?
They did.
And you also gave them a copy of your screenplay, didn't you?
Yes, I did.
You cooperated fully, right?
Yes.
Now, with regard to your work as a screenwriter, you described for Mr. Darden that you'd won an award at some time in the past through the Writers Guild of America. Tell the jury about that award and whether or not there was a cash stipend that went along with that award.
Objection, irrelevant.
Or you may answer.
Yes, it was an award I won in 1984 through the Writers Guild of America East Foundation. So it's a competitive award for original screenplays. And there was a cash stipend. And along with that, a request that you write another screenplay with a mentor of your choice. The cash stipend I used to purchase a computer and my laptop.
All right, and you've done other screenplays in addition to this one, Men Against Women, isn't that correct?
That's correct.
Now, you've shared with us in this jury that the premise of Men Against Women is sexism, is that correct?
Yes.
And are you opposed to sexism?
Yes,
Yet you write a play about sexism, right?
that's correct.
And would you describe for the jury why, as a writer, you write a play about sexism?
It's a topic I wanted to explore from the man's point of view and a woman's point of view to try to understand better why some men would be so upset by what they felt as the incapable abilities of some women in areas of high crime, that they would form an organization called Men Against Women and be a part of that, and why some women would be upset with some of the things that men were doing and making it difficult for them to perform their jobs, embarrassing them or humiliating them. So I wanted to try to to explore those issues and develop some kind of a dialogue or discussion.
Now, I'd ask you a question before with regard to the whole concept of racism and writings regarding racism. During the time that you, 1985, when you first encountered this man, Mark Furman, you described for us, I believe, that you were employed at UCLA working with Terry Donahue. Is that correct?
I was employed at UCLA working under the auspices of Coach Terry Donahue in conjunction with the College of Letters and Sciences.
All right.
Yes.
And in that connection, did you work frequently with African-American athletes?
Yes, I did.
Would you describe for the court what you did during that time and the jury?
The the NAA, the National Association,
NAACP?
No, not the NAACP, it's a college.
NC2A?
Yes, NC2A, thank you very much.
Those alphabet organization, okay.
Right.
NC2A,
Yes,
okay.
had demanded that athletes be studying courses in their field of expertise and not taking any class. So it was incumbent upon the athletic department during that period to hire educators who they felt would be able to work with athletes who were high-risk athletes that they felt might need extra counseling, extra tutorial time, and extra times of understanding time management and study skills. So they would hire someone such as myself to work with what they called high-risk athletes, and that's what I did during that time.
And would some of these high-risk athletes be African-American youngsters?
In the beginning, they were, yes.
And did you interact with them on a daily basis?
Yes,
Do you enjoy that work?
very much.
Now, you were asked some questions about a document that Mr. Darden marked, and the top of it is called Non-Disclosure Agreement. May I approach you on?
You may.
And do you know what a non-disclosure agreement is, Ms. McKinney? Generally?
Generally, I do.
Well, what is it?
I've just recently learned what a non-disclosure. It's an agreement that you would give to another party, and what it does is ask them not to discuss the material, not to show the material, not to copy the material. They cannot disclose or talk about the product or the material to anyone else.
Okay. As I understand
Is that
it-
accurate? That's my understanding.
I think so. As I understand the letter that I placed before you, August 18th, 1995, from Mr. Michael Wiener, addressed to Michael Wiener from your lawyers, you had never seen that before Mr. Darden showed it to you. Is that correct?
That's true.
And with regard to, since you came to California, have you at any time ever authorized anyone to try and sell these tapes or screenplay? Strike that. These tapes or transcriptions.
No,
All right. And with regard to your lawyers, did they at some point tell you that would be malpractice if they didn't try to find out for you what the value of these tapes and transcriptions were? They tell you that?
yes, they did.
And did they try to find out the value of these tapes and transcriptions?
Yes.
All right.
Mr. Carpenter, you need to stand there
No,
because
no.
you're blocking juror number 7 there.
Thank you. Now, thank you. Now, in that connection, even though you've now found out the value of these items, and I won't ask you what the value is, you still have not tried to sell these, have you?
No, I have not.
What you do want to sell is your screenplay, Men Against Women, isn't that right?
Yes, that would be lovely.
That's what you want to do, isn't that right?
Yes.
All right. Now, ma'am, you mentioned in response to one of Mr. Darden's questions about specific cover-up as relates men against women. And I want to ask you, in that regard, what did you mean when you talked about cover-up as relates to men against women in this screenplay that you ultimately wrote? Can you tell us about that?
Yes. One of the reasons why I was discovering that some women were having a difficult time being accepted into the police department in certain male circles.
Being responsible.
Overruled.
You may continue.
In certain male circles was that some officers didn't trust their confidentiality, their ability.
All right, next question. Next question.
Well, can you continue and tell us? Can you answer the question, please?
Okay.
It is turning into a narrative once you ask the next question, Counsel.
All right, sure. When Mr. Darden asked you about this cover-up as relates men against women, can you succinctly state for this jury what you meant and what you had reference to?
Yes.
I'm going to object. One that question.
Overruled. Go ahead and answer the question.
Some women on the police department were not willing to follow the...
No, overruled. Answer the question, Ms. McKinney, please.
Some women on the police department were not willing to adhere to some of the cover-ups that men were.
Objection.
Ask another question.
Well, you said that some women on the police department were not willing to hear.
Your Honor, may we approach the...
This is not the topic, Counsel. Let's redirect it back into that topic.
All right, Your Honor. With regard to this subject to cover-up, can you tell us what you had reference to, specifically in the area that Mr. Darden asked you about cover-ups as relates to women and men on the Los Angeles Police Department?
Objection, the question is vague. 352.
Ms. McKinney, we're speaking about the specific topic about the controversy about women as police officers in areas of high violence or high crime, the topic of your book.
Right.
Yes.
Okay. That's the sexism issue that relates to why women were unable to cover up some issues the same way men were, and it's related.
Objection,
They're
Judge.
interchangeable. They're interchangeable. Sexism was what I was looking into, but what I found out was related to cover-ups that men were purporting.
Overruled.
I couldn't get what I'm saying.
Finish the question.
Finish
the answer.
please.
Sexism was the issue that interested me. It was what I was looking into. But what I was finding is that
Overruled.
what I was finding was that sexism is inextricably related to certain cover-ups that some men on the police department are doing, and some women are not able to agree with that or follow along those lines. And that was a huge schism between men and women.
And in that connection, can you give us like an example of this schism between men against women where there was a resulted as a result of a cover-up?
352, Your Honor.
Sustained. Sustained. We've covered it.
Second. Let me ask another question in this regard, Your Honor. Did Mark Furman ever explain to you why he wouldn't trust a woman in this, from a standpoint of cover-ups?
Sustained. It's not relevant.
Now, Mr. Darden asked you a lot of questions about why you didn't stop Mark Furman or using this N-word or whatever. Do you recall those questions?
Yes.
And is there any doubt in your mind now, as you sit here, that Mark Furman used this horrible word 41 or more times during the times that you were talking to him? Any doubt in your mind at all? Oh, well.
No.
And those were his words coming from his mouth? Is that right?
That's correct.
Those weren't your words, were they?
No.
Before I conclude, may I approach this for a moment, please?
With the court reporter, please.
Thank you.
Mr. Cochran.
Good questions. Your Honor, when you indicated that Mr. Furman had used this word some 41 or more times, how do you know that? Did you count them yourself? On the transcripts and the tapes?
No, I did not count them.
All right, you've seen them, however, in the various and sundry documents filed with this court?
It's leading.
Okay. Have you had occasion to review any documents filed with this court with regard to the use of that word?
Overruled.
Yes, I reviewed the offer of proof submitted by the defense.
Basis.
Irrelevant.
Overruled.
And you've counted those documents, right?
Yes.
All right. Now, I have nothing further at this point, Your Honor.
All right. Recross.
Mr. Kenny, you testified in North Carolina on July 30, is that correct?
I don't recall the exact date. That sounds
Would it refresh
Close.
your recollection if I showed you a transcript? Sorry, the date's wrong on the transcript. In any event, are you aware that the DA's office attempted to subpoena these tapes from your attorneys on July 14?
again. I don't.
Are you aware that the DA's office obtained a court order from the judge attempting to subpoena to this court these very same tapes from your attorneys on July 14?
Overruled.
No.
Are you aware that on July 10, the DA's office addressed the court and advised the court of the existence of these tapes and sought guidance from the court in terms of recovering these tapes?
On July 10th,
Yes.
again, please.
Yes.
And did what? Could you say what you did again?
And we went to Judge Ito and told him that we heard of the existence of these tapes, and we asked the court for guidance and help in obtaining these tapes and causing them to be delivered to the court.
No, I'm not. I'm not aware of that.
Just so it's clear, when was it that you authorized your attorneys to contact media entities to determine the value of the tapes and transcripts?
Object to the form of that question, there was no testimony from media entities.
Rephrase the question.
When was it that you authorized your attorneys to contact any entity or any person or any organization or any business or corporation?
I don't recall a specific date that I authorized my attorneys to do that.
Recall which month?
Which month?
Yes.
It would have to be July or August.
Okay. Well, do you know which one?
No, I don't.
Okay. Was there any contact with the National Enquirer?
Object to the form of
What's
that question, by whom?
By your
Rephrase
attorneys?
the question.
Did you have your attorneys contact the National Enquirer?
I don't know if my attorneys have contacted the National Enquirer. They may have. I don't know.
Okay. Did you have your attorneys contact media entities outside the United States?
I don't know. We were contacted by people I didn't even know, and my attorneys would relay that information to me. So I don't know if, for instance, the National Enquirer would have called my attorneys, or who would have contacted them.
Thank you. That's all.
Mr. Cochran.
I presume there has been a great amount of interest in these tapes and transcripts by a lot of the media, isn't that correct?
That's correct.
But you refused steadfastly to sell these tapes, isn't that correct?
That's correct.
And you've even sent some portions of these tapes to Mr. Mark Furman, isn't that correct? Back in 1985 or earlier?
Yes.
Thank you very kindly. Nothing further at this particular point, Your Honor.
Mr. Darden.
Did you say? Excuse me. Then. Did,
I'm sorry, I'm
Transcript.
asking the questions.
Mr. Darden.
You said you sent tapes to
I
Mark
sent
Furman?
transcripts
Okay.
to Mr.
And
Furman.
with regard to the tapes and the transcripts, who owns those tapes and transcripts? You or Mark Furman?
I assume I own them. They're my tapes, my transcripts.
Mr. Cochran?
Just one last question. Your lawyers and you have made these tapes and these transcripts available to Mark Furman and his lawyer. Isn't that correct? Oh. Oh, isn't that correct?
Yes, as well as to anyone else who's asked.
And the others who've asked can go to your lawyer's office and listen to these things, right?
Anyone who has standing who's asked.
Some standing, like an
LA
agency or whatever.
Commission, LAPD, yes.
All right. Thank you for your time.
If I may, the LA Police Commission has come over to take a listen to these tapes?
That my attorney's office has been available for anyone who has standing, who has called the attorneys, to listen to the tapes and take copious notes on the transcript. They have spent hours, days there taking notes. But they're under a protective order, with only the prosecution and the defense actually having copies of the tapes or the transcripts.
And the United States Department of Justice, have they been there to listen to the tapes yet?
I don't know.
Has the FBI been there yet?
I don't know.
They will be, won't they?
I don't know.
That's all.
All right, Ms. McKinney, at this time, I'm going to allow you to be excused. However, you are subject to recall. All right?
Thank you, Judge.
All right, you may step down. All right, is your next witness available?
May I check and see?
All right. Actually, once you have one of your, Mr. Douglas, check. Let me see counsel at the sidebar with the court.
Okay. And our next witness is a Mr. Roderick Hodge. Mr. Hodge, please come forward, sir. And along with this counsel, Glenn.
All right. Mr. Cochran, why don't you retrieve the exhibit that's up on the witness stand first, please?
Morning.
Morning, counsel. Your name for the record, please?
Judge Irv Miller on behalf of Mr. Hodge.
All right. Morning, counsel. Mrs. Robertson.
You solemnly swear that the testimony you may give in the prosecution before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat on the witness stand and state and spell your first and last name to the record.
First name is Roderick, R-O-D-E-R-I-C, Hodge, H-O-D-G-E.
Thank you.
Good morning, Mr. Hodge.
Morning, Scott.
Could you move the microphone a little bit back, sir?
Just pull it close to you. Thank you.
Close to you. Thank you. Mr. Hodge, just tell us, what city do you presently reside in?
In Dalton, Illinois.
And is that near Chicago?
Yes, it is just south of Chicago, 8 miles south of Chicago.
And have you come here today pursuant to a subpoena issued by this court from Illinois?
Yes, sir.
And how long have you been in California?
As of late, approximately 1 week.
About a week waiting to testify?
Yes, sir.
Now, what is your occupation generally, sir?
Thank you. I'm currently a communications repair technician with Flame James Communications in Chicago, Illinois.
All right. I'd like to cut through the chase and get right to it. Did you formerly live in California before you moved to Illinois?
Yes, sir.
And I'd like specifically to direct your attention back to the month of January of 1987, specifically January 11th of 1987. Did you have occasion to see or interact with a person by the name of Mark Furman?
Yes, sir, I did.
Was he a Los Angeles police officer at that point?
Yes, sir.
On that date, were you taken into custody by Mr. Furman?
I believe so. I believe it was that date. Yes, sir.
All right, was it the 11th or 12th, or do you know the exact date?
I'm unable to call the exact date, sir.
Was it in January of 1987?
Yes, sir.
All right. And do you remember who Mr. Furman's partner was on that time?
Yes, sir. It was Vitriano. I just referred to him as Vitriano. I believe it was Tom Vitriano.
Tom Vetrano?
Yes, sir.
All right. And at some point, were you placed inside of a police vehicle?
Yes, sir, I was.
And after you were placed inside that police vehicle, were you taken somewhere?
Yes, sir.
Do you remember which officer was driving the vehicle?
Yes, sir.
Who? Which one?
I was Vitriano.
And who was Vitriano's partner officer at that time?
Officer Furman.
All right. And where was Officer Furman seated in the vehicle, if you recall?
On the passenger side of the vehicle,
And where were you seated?
in the rear of the vehicle.
Were you handcuffed at that point?
Yes, sir.
And did Officer Furman say something to you as he was seated in the right front passenger seat and you were in the rear portion of that police vehicle?
Yes, sir, he did.
You tell the ladies and gentlemen of the jury what Officer Furman said to you on this date in January of 1987?
Yes, sir. At the time, Officer Furman turned around, looked at me, and told me, "I told you we get you, nigger."
Did you hear what you heard him clearly?
Very clearly, sir.
And when he said this to you, can you describe for us the tone of voice that he used?
Anger, hatred, just something from deep inside, if you would, just very ugly.
And when he made this statement to you, can you describe for the jury how you felt? Oh.
Belittled, scared, very, very angry. I could use many more adjectives, but those
Does that encapsulate how you felt?
lightly, yes. Very lightly.
Well, thank you very much for coming today. Thank you further on.
People?
Mr. Hodge, thank you for coming, sir. Sir, you said 14 Avenue,
Yes, sir.
you were arrested by Petrano and Furman on January 13, 1987, is that right?
I'm unable to call the exact date, sir.
By the way, were you only arrested once by Petrano and Furman and placed in a police vehicle?
To any beyond scope,
Sustain.
Trying to establish the date, Your Honor.
beyond
The date of January 87 is close enough.
Then perhaps I should approach then.
All right, let me see over here. Sidebar. Thank you, counsel. Proceed.
Mr. Hodge, did you complain to the LAPD about the manner in which you were arrested by these two officers?
On which occasion, sir?
On the occasion you just described for Mr. Cochran,
Yes, sir.
you filed a formal complaint.
Yes, sir.
When you were arrested, were you holding a drill or something in your hand?
beyond scope.
Sustain.
Let me show you a copy of an IOD complaint. By the way, Did you have any portion at all of the IED complaint you filed?
At this time,
Excuse me, counsel, I think your question assumes IAD and that the jury knows what we're talking about here.
Certainly. Okay. You complained to Internal Affairs Division at the LAPD. Is that right?
I believe it was internal affairs. Yes, sir.
Okay. And you were interviewed by them?
Yes, sir.
And were you interviewed by a supervising officer at West LA Station as well?
I believe it was a supervising officer.
And your name is Robert T. Hodge. Is that correct?
No, sir.
Okay. What's your name?
Roderick T. Hodge.
And what's your birthday?
August 22nd, 1964.
That's it. I just showed. I'll give Mr. Cochran a copy.
All right.
Is that the? If you just take a look at that, please, sir.
Right.
Does that refresh your recollection that the date of arrest was January 13, 1987?
Not really, sir, but take it.
Okay. Does that appear to be the complaint that you filed with LAPD?
Yes, sir, it does. It appears to be.
And on the last page of that document, does it indicate that you had a second interview with someone from Internal Affairs on January 23, 1987, an interview with a Sergeant Lamprey?
Yes, sir, it does indicate that.
Okay. And did you have such an interview?
Yes, sir, I believe so.
Okay. Nowhere in this Internal Affairs complaint is it mentioned that you complained of Furman's use of any epithets. Is that correct?
I haven't read over the entire of the interview, sir.
Okay. Your Honor, may this document be marked People 604?
People's next in order 604.
Would you like to take a moment and see?
How many pages is this document, Mr. Darden?
It's 17 pages, Your Honor. In response to this question, I have no additional questions.
All right, since it appears to be typewritten,
Yes, sir.
single page. All right, then what I'm going to suggest we do is allow Mr. Hodge the time to review the document, and we'll conclude the examination after the lunch hour. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. As far as the jury is concerned, we'll stand in recess until 1:30. All right, Mr. Hodge, you can step down. All right, thank you. All right, Mr. Hodge, would you resume the witness stand, please? All right, the records reflect that Mr. Roderick Hodge is on the witness stand undergoing cross-examination by Mr. Darden. Good afternoon, Mr. Hodge. Mr. Hodge, you're reminded, sir, that you were still under oath, and Mr. Darden, you may continue with your cross-examination.
Do you still have the documents from this morning, Mr. Hodge?
No, sir, I gave them back to your assistant.
At any event, do those
Ms.
documents...
Lewis. All right, Mr. Hodge, why don't you pull the microphone close to you, please? Thank you.
Did you see the epithet indicated here in these documents?
No, sir.
Okay. You think it might be contained in some other document?
Speculation.
Rephrase the question.
At any event. Thank you, Mr. Hodge.
Mr. Cochran.
Thank you very much. Good afternoon, Mr. Hodge.
Sir,
Mr. Hodge, is there any doubt in your mind that in the month of January of 1987, Detective Furman referred to you as a nigger?
sir, there's no doubt in my mind whatsoever.
Is that something you'd forget?
Something you don't forget.
Now, Mr. Hodge, sir, with regard to this document that Mr. Darden showed you, did you get a chance to look this document over at lunchtime?
Yes, sir, I did.
And with regard to that document,
Or
Dr.
I haven't heard
Mark,
the
yeah.
question yet.
with regard to this document, may I approach you?
You may.
With regard to this document, indicates that after your encounter with Mr. Furman
Hearsay.
and the other,
Hearsay, Your Honor.
may I finish the question yet?
Finish the question.
After your encounter with Mr. Furman and the other officers on that day, you went down and made a complaint for their behavior, isn't that correct?
That's correct, sir.
And I'd like to show you this document, which is, what's this people's, what you're,
This is 604.
I want you to take a look at 604. And first of all, you are Roderick T. Hodge, is that correct?
Yes, sir, that's correct.
And with regard to the type of complaint you rendered against these officers, do you see that? Do you see this box here under type of complaint?
What's the objection? Overruled.
Do you see the type of complaint?
Oh, yes, sir.
All right. Do you recall that you went down at some point after the contact with Mr. Furman and the other officers and made this actual complaint?
There were a couple of times, yes, sir.
All right. Did you, in addition, did you go to West Los Angeles on some occasion?
Yes, sir.
Did you also go someplace else and make a complaint?
Yes, sir, I did.
And where'd you go to make that complaint?
Downtown location, what we refer to as the Parker Center.
All right. Did you go to Parker Center on the same date you went to West Los Angeles?
No, sir.
That was on a different date?
Yes, sir.
And why did you go to both locations to make complaints about the conduct of these officers?
Overruled.
My brother, who's a
Well,
law
hold on.
enforcement,
Hold on. You made 2 complaints, 2 places, both at West LA and downtown at Parker Center, correct?
sir, I made 3 complaints.
3 complaints. Where else?
My brother advised me that West Los Angeles Police Department would not pursue.
Sustain.
Let me just go question by question, Your Honor. You have a brother in law enforcement?
Yes, sir, I do.
What kind of law enforcement was he in?
The Department of Corrections.
Did you have occasion to discuss with your brother, who was in law enforcement, whether or not you should make a complaint?
Yes, sir.
Did he give you some advice?
On many occasions.
And after you got this advice from your brother, who was in law enforcement, where did you go?
To the Parker Center.
And that was after you'd been to West Los Angeles?
That's correct.
And did you make a complaint at Parker Center?
Yes, sir.
And you said you went a third place. Did you go some other place to make a complaint?
No, sir. I made 2 complaints at the West LA station and one at the Parker Center.
All right, so that was the third complaint?
That's correct.
All right. Now, with regard to these documents that Mr. Darden showed you, did you notice anything unusual about the pages? Did you look at the pages and look at the numbers of those pages?
You want to show him 604, the actual exhibit?
Sure, I'll be glad to, Your Honor.
All right, because we're talking about 2 different documents here.
Thank you. I want you to look at the last 2 pages of 604. See if there's anything unusual about the numbering of the pages there.
Yes, sir.
What'd you see? Tell the jury what you see there.
Well, it goes from page 6 to page 17.
You know what happened to pages 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16?
No, sir, I would have no idea.
Now, with regard to that document, look in the upper right-hand corner under the type of complaint that you made against these officers on January 13th, 1987. Do you see that?
Yes, sir.
And what does it say?
Objection.
Sustained.
I may want to approach this briefly if I could to show
All
the
right,
court
with
something.
court order, please.
Thank you.
Mr. Cochran.
Thank you, Your Honor. Now, Mr. Hodge, when you made these three complaints to the Los Angeles Police Department, did you include a complaint for discourtesy of the officers involved on that date, including Mr. Furman?
Yes, I did.
When you included this complaint for discourtesy, that include him calling you or saying, we told you we were going to get you, nigger?
Yes, sir, that's correct.
Now, you have not tried to profit from your involvement in this case in any way, have you?
No, sir, not at all.
Like, have you tried to stay away from publicity in connection with this?
As far away as possible, yes, sir.
Were you contacted by ABC News back in March of this year?
Yes, sir.
And did
Excuse me, Mr. Hodge, would you just pull the microphone a little closer, please? Thank you. Mr. Cochran.
Thank you. You were contacted by ABC News back in March of this year?
That's correct.
And you did not go on camera at that point, did you?
No, sir, I have not.
You haven't tried to sell your story to anyone, have you?
No, sir.
You came out here a week ago from Illinois because you were subpoenaed, is that right?
That's correct.
And as soon as you can, do you want to go back home?
Yes, sir.
Thank you very much for coming, sir.
Mr. Darden?
Have a safe trip home, sir.
Thank you, sir.
Thank you, man.
All right, Mr. Hodge, thank you very much, sir. And if you would return that document to Mr. Darden, please. All right, thank you, counsel. All right, let me see counsel at the sidebar without the court board, please.
One stipulation is on the way down now.
I believe Mr. Newfield has another stipulation.
All right, Mr. Neufeld, you have a stipulation that you've discussed with
Yes.
Ms. Clark and Mr.
Ms.
Darden.
Clark, yes. And the stipulation is, what number are we up to? Defense exhibit, Your Honor?
1369.
Okay,
All right, we'll
That-
mark the stipulation 1369.
yes, which is simply the sunrise and sunset times for Los Angeles, California. And in particular, for the stipulation that on June 13th, 1994, the sun rose at 5:41 a.m. Pacific Daylight Time.
Yes.
All right, and ladies and gentlemen, if you recollect, the stipulation is agreement between the attorneys as to certain facts, and you were to assume those facts to be true for the purposes of making your determinations in this case. All right, and Mr. Darden, you said that there's another stipulation on its way down?
Yes.
All right, ladies and gentlemen, while we await that stipulation to be brought down from upstairs, I am going to be excusing you in a few moments to be taken up to the larger lounge upstairs so you'll be a little more comfortable. There are a couple of more legal issues that I need to take up with you. And as you notice, I was having a conversation with the lawyers over at the sidebar without the court reporter just to discuss with him informally the scheduling for the remainder of the trial. And I anticipate on the basis of that discussion that the defense should be concluding the presentation of their case this week. So just a few more legal issues I need to resolve, and then we'll hopefully conclude that phase of the trial. So just to let you know, we are making progress. But I do have a few more legal issues I need to iron out before we get to you. But I anticipate we may have some additional testimony for you this afternoon.
Some modification is on the way down.
Okay.
The courier has already left. 18.
Be a better use of our time than to take our recess at this point, excuse the jury, and then launch into our issues. I'm sorry? Ms. Clark?
Thank you.
Okay. All right, then, as far as the jury is concerned, then we'll stand in recess. Remember my admonitions to you. As soon as we clear the courtroom with the jury, we'll reconvene. All right, thank you, counsel. The legal issues we need to resolve before we resume with and complete the defense case, correct?
Yes, Your Honor, I believe that is correct. If the court pleases, just as a matter of direction, I would ask the court to listen to Dean Ullman first in order of presentation, please.
All right, as to what issue, Mr. Ullman?
This would be as to the suppression motion, Your Honor. And I also have an offer of proof with respect to the remaining testimony of Laura McKinney.
Well, let's take these things one thing at a time.
All right, perhaps the offer of proof. It is our contention that in the cross-examination of Laura McKinney by Mr. Darden, the questioning with respect to discussions between Ms. McKinney and Detective Furman with respect to cover-up opened the door to allow the jury to hear the portion of McKinney transcript number 1. Actually, this is not a taped transcript, but it would be page 41 of McKinney transcript number 1, in which there is a discussion of the departmental cover-up with respect to the performance of women within the department. It starts with Furman. The second time the name Furman appears on page 41 and goes down to the end of the page. We believe the door has also been opened to a discussion which appears in transcript number 11, beginning at page 19 and proceeding through page 26. This is a discussion between Ms. McKinney and Detective Furman regarding how she could portray in her screenplay the cover-up that would be necessary where an officer is being investigated and needs to create the appearance of being one place rather than another. And Detective Furman describes how logs can be falsified. Alternatively, if Your Honor will not allow us to play the tapes, we believe that Ms. McKinney could describe these conversations in terms of their general tenor. The exchange in tape number 11 that I'm talking about relates directly to Ms. McKinney's testimony and Mr. Darden's questions about the relationship between the men versus women theme of her screenplay and the topic of cover-ups. That is, the ability of male officers to cover up and of female officers not having the same ability to cover up their tracks.
All right, were you going to... All right, never mind. People, Mr. Darden.
I have an idea of what Mr. Ullman is talking about, and I think we argued these issues this morning for the most part, and I would say objection on the same grounds as stated this morning. I would say that it is hearsay. That one, what number was it? Okay, and the number 11 proffer was one that was clearly fictional. And why do we have to go back there? Okay, the damage is done. I think the court understands what happened this morning with that particular witness, and we object.
All right, Strowman.
With respect to the hearsay.
Wait, hold on, one second.
Judge, would the court ask counsel to read the information? Judge, would you? transcript number 1, pages 41 to 42. They don't relate directly to the issue counsel has attempted to raise at this point. They're irrelevant to that testimony, to McKinney's testimony as it related to cover-ups and women.
All right, Mr. Allen.
With respect to the hearsay issue, Your Honor, of course, these portions of the transcript are not offered for the truth of what is asserted. They are offered to demonstrate the nature of the conversation between Ms. McKinney and Detective Furman. There was an attempt to portray the nature of these conversations in a false light through Mr. Darden's cross-examination. He was suggesting that Ms. McKinney was attempting to sensationalize this screenplay, that there was even allusions to a possible illicit relationship between Ms. McKinney and Detective Furman. There was a suggestion that she was attempting to get Detective Furman to portray the information that he was presenting to her in a dramatic and exploitative way. And we believe that the jury's entitled to see and to hear how these conversations took place, especially in the context of the question of cover-up that Mr. Darden alluded to. So the jury can see the context. And the context, as Your Honor knows, makes all the difference in the world in explaining how these conversations took place and what was actually going on between Laura McKinney and Detective Furman.
All right. Thank you, counsel. All right. As to the second example first, the discussion within the context of the screenplay, the question being from Ms. McKinney as to how would a certain cover-up be portrayed for the purposes of the screenplay. That's clearly in the discussion of the creation of a fictional screenplay. As such, it's not relevant. Objection will be sustained. As to the issue of the department's cover-up of the performance of women as police officers, interesting topic, but not for this trial. The objection is likewise sustained on the basis of relevancy. All right, next issue.
The next issue, Your Honor, is the renewal of the defendant's motion to suppress.
All right.
And I think an appropriate place to begin is with the legal standard to be applied in terms of the impact of newly discovered evidence. And we believe that the leading case on this question is People versus Ramsey, cited in our brief at page 7, which quite clearly holds where additional evidence is presented, the findings of the magistrate, to the extent they are affected by the additional evidence, are not binding on the Superior Court. This allows the Superior Court to exercise its independent judgment on issues on which additional evidence is introduced. The additional evidence that we wish to introduce relates directly to the credibility of Detective Mark Furman. And our position, quite simply, is that Your Honor, in considering this evidence, is not bound by whatever findings were made with respect to Detective Furman's credibility in the municipal court, but that you are to exercise your independent judgment on the issue of his credibility. Now, the prosecution has contended that what we are offering with this additional proffer is simply evidence going to his general credibility. And I want to point out to the court the very clear relationship between the portions of the McKinney transcripts and tapes that we are proffering as new evidence on the credibility of Detective Furman and the testimony that he presented on the motion to suppress. And I think it's fair to call the court's attention to the fact that there were only 2 detectives who testified on the motion to suppress, Detective Van Adder and Detective Furman. And Your Honor will recall that in the context of a number of misrepresentations made by Detective Van Adder in the affidavit for the search warrant, this court made a finding that Detective Van Adder had a reckless disregard for the truth. So that the credibility of Detective Furman becomes a very, very important aspect of the determination of the defendant's motion to suppress. Do we or should we put any faith in the testimony of Detective Furman with respect to the circumstances that led up to the warrantless search of the defendant's premises on the morning of June 13th? Now, we have essentially, well, let me identify each of the issues where we believe the credibility of Detective Furman is in issue. First of all, with respect to the justification for the entry to the premises. As Your Honor will recall, the explanation offered by the detectives for their trip from Bundy to Rockingham was that it was for purpose of making a notification. Mr. Simpson was not a suspect. Their reason for going to his residence was to notify him of the death of his former wife and to make arrangements for the care of his minor children who had been found in an upstairs bedroom at the Bundy scene. It was only after they arrived at the premises and a speck was found on the door of the Bronco above the handle to the driver's side door that the circumstances were transformed. And the officers determined that they had some sort of emergency that justified an immediate entry to the premises without a warrant. And of course, the discovery of that speck on the door was a discovery by Detective Furman. It was Detective Furman who testified he went by himself from where the officers were gathered at the gate to enter Mr. Simpson's premises, that he noticed that the Bronco was parked in a very haphazard manner, as he put it, that he went over and he made the discovery of the speck on the door. Now, in that context, it is significant that this is the same Detective Furman who, in the context of the McKinney tapes and transcripts, offers the following comments. This is Miss McKinney, and I'm reading from her transcript number 1, pages 24 to 25. So if you ripped up his identification, you're not going to mention that you ripped it up, are you? And he answers, never. But that doesn't mean I didn't say I didn't. Nobody asked. And the interviewer, Miss McKinney, asks, how about if somebody asks? And Furman says, well, then I won't. That's an investigation of a police report. When you say falsification of an arrest report, that's when somebody's walking down the street and I see him throw something, but I don't see what he throws. Then I go back where he threw something and there's a gun. Now, if you want to let that guy go, if you're a citizen, do you want that guy on the street or in jail? Obviously, you want him in jail, unless you're a jerk too. So the only way to put him in jail is for the policeman to say, I saw him throw that gun. Interviewer, Miss McKinney. Oh, identifying the action with the object? Furman. Of course he threw it. What are the odds of going to a place where he threw something and having that be a gun? 10 million to 1, 30 million to 1. I don't know what the odds would be, but it's got to be astronomical. So if that's considered falsifying a report, and if some hype, says, whatever I shot 2 days ago, and you find a mark that looks like 3 days ago, pick the scab, squeeze it. Looks like serum's coming out, as if it were hours old. It's a hard find. You just can't find the mark because he's down. His eyes don't lie. That's not falsifying a report. That's putting a criminal in jail. That's being a policeman. Now, obviously, Detective Furman's definition of being a policeman as including making up the facts that are necessary to put someone in jail once you've determined that person should be in jail is highly relevant to his testimony of finding the one iota of evidence that will justify or be offered as justification to make an immediate entry to Mr. Simpson's premises. And we believe it is highly relevant that in this example, he is discussing the manufacture of blood evidence. He is discussing scratching a scab to make fresh blood to provide an officer with probable cause to make an arrest. And he's saying, that's not falsifying a report, that's being a good cop. The second instance where the justification for the conduct of the officers on the morning of June 13th is questioned relates to the limited purpose for which they made entry to the premises. This supposed emergency that was created by the discovery of this speck on the car door meant that in addition to the purpose of locating Mr. Simpson and notifying him of the death of his former wife, making arrangements for the care of their children, we now add this new justification that there may be a victim on the premises, or there may be a perpetrator lurking on the premises. That is not a justification that includes searching for evidence. And what does Mr. Furman do? Mr. Furman goes to Cato Kalin's room, enters the room, interrogates Mr. Kalin, searches the room, searches Mr. Kalin's clothes, looks at the soles of Mr. Kalin's shoes, and does not ask him any questions about whether there are any potential victims on the premises. He simply asks about the thumps that Mr. Kalin reports hearing on the wall the night before. There's no follow-up questioning at all in terms of expressing any concern with respect to whether there are any victims or perpetrators lurking about. And in this context, I think it's important to remember that this is the same Detective Furman who, in the context of his conversations with Miss McKinney, says, and now I'm quoting from pages 33 and 34 of that same transcript number 1, "So under what did you arrest him?" the interviewer asks. Furman: "I didn't arrest him under anything, just took him to the station, ran him for prints, gave them to the detectives to compare with what they've got in the area. I'll probably arrest a criminal that way." And he's referring here from the prior context to an arrest that he had made himself just the night before. And the interviewer asks, "So you're allowed to just pick somebody up that you think doesn't belong in an area and arrest him?" And Furman says, "I don't know." Interviewer: "Well, I mean, you did, so?" And Furman says, "I don't know. I don't know what the Supreme Court or the Superior Court says, and I don't really give a shit. If I was pushed into saying why I did it, I'd say suspicion of burglary. I'd be able to correlate exactly what I said into reasonable cause for arrest. And the interviewer asks, but nobody usually crosses you, do they? Because they know if you're pushed, you're going to come up with something. And Furman responds, well, my supervisor has confidence that I know what I'm doing, so they don't make beefs about it. This is obviously highly relevant to the conduct of Detective Furman in essentially entering those premises to search for evidence and then making up a reason later to justify what he had done. The next example of the relevance of these newly discovered tapes relates to the question of the scope of the search activity that Detective Furman then engaged in. Your Honor will recall that after Cato Kalin told him about the thumps on the wall, Detective Furman told no one else about that. He didn't mention that to any of the other detectives. He simply said to Detective Van Adder, you ought to talk to this guy, and then went off by himself to the rear of the premises, where he was for approximately 15 minutes, according to his own testimony. And what's he doing back there? He says, I'm looking for a victim. I'm looking for the body of somebody that may have been injured. No basis whatsoever to assume that there would be any victim back there other than the thumps on the wall, and yet he didn't question either Kalin or Arnell Simpson about whether they heard cries from anyone back there, whether they heard any other noises back there. He goes back and he looks around for approximately 15 minutes, and then he takes the other detectives one at a time to show them what he allegedly discovered. Well, Your Honor, this is the same Mark Furman who, in his conversations with Laura McKinney, and I am now quoting from tape number 3 at page 3, makes the following comments. Furman, well, I really love being a policeman. McKinney, why do you love being a policeman? Furman, when I can be a policeman. It's like my partner now. He's so hung up on the rules and stuff. I get pissed sometimes and go, you just don't even fucking understand. This job is not rules. This is a feeling. Fuck the rules. We'll make them up later. Well, there are rules about what kind of search activity a police officer can engage in without a search warrant. The activity of Detective Furman on the morning of June 13th raises serious questions about whether he followed those rules. And the attitude exhibited in this exchange that is on tape in the McKinney tapes certainly raises a question that should be asked about Detective Furman's understanding of the rules and limits on the kind of activity that he could engage in. The next issue relates to the role of Detective Furman in the investigation of this case after he is taken off of the case at approximately 2:30 in the morning. Your Honor will recall that almost 3 hours after he is removed from the case, it is Detective Furman who leads the other detectives from Bundy to the Rockingham residence of the defendant. It is Detective Furman who finds the speck on the Bronco. It is Detective Furman who then leads the detectives over the wall into the premises. And it is Detective Furman who ultimately finds the glove. And with respect to all of this investigative activity, there are no notes, there are no logs, there are no reports. His testimony is, I stopped making any record of what I was doing as soon as I was taken off the case at approximately 2:30 in the morning. Perfect setup. No way to double check any of his activity in terms of what happened after he was relieved from the case. And, Your Honor, this is the same Detective Furman who, in his exchange with Ms. McKinney, and this is on the tape 6A, I'm reading from page 3 to page 4. This is embarrassing. This is Detective Furman speaking. Then you go to court, and I'm the only one who knows how to testify. You have 5 officers on the case, and I'm the only one there that knows how to testify. The DA goes, yeah, but you were the 4th car, but would you testify? Yeah, but you did see, I saw it, don't worry about it. Yeah, I saw him do that. Yeah, I saw him do that. Yeah, okay, goodbye. Why do I have to do everything? That's what it is coming down to. I have to fight the guy, I have to catch the guy, I have to keep the guy's mouth shut at the station because they're not going to do it for a female. I can just walk by and go, shut up or I'm going to kick your face in. Now, the relevance of that, obviously, is that it's a pretty good description of what was going on the morning of June 13th. Detective Furman had to do everything. And what he's saying in this exchange is doing everything means also providing whatever testimony is necessary, regardless of what happened. We believe that the prior conduct of Detective Furman is highly relevant to the credibility on the suppression issues. We're not talking about general credibility here. We are talking about a police officer who believes that lying to justify an arrest or a search is okay, that the end justifies the means if he has concluded that the suspect is guilty anyway. And this is the same Mark Furman who says to Ms. McKinney, and this is transcript 9, pages 11 and 12, Furman, absolutely, let me put it to you this way. In almost 12 years on the department, I have never felt guilty one day, one split second. Ms. McKinney, why? Furman, because all those people out there deserve exactly what they get, and probably 20,000 times more. Ms. McKinney, so you feel that you make judgment calls in a way that ensures those people to get what they deserve, and so therefore there is no reason for you to feel guilty about anything you do? And Furman responds, well, yeah, it's the same thing. If you're in a rice paddy in Southeast Asia and a guy in black pajamas is running across a rice paddy with an AK-47, are you going to shoot him or wonder if he's really a communist or if he just stole those clothes from a VC soldier and he's running away? You shoot the son of a bitch and you don't worry about what he was. You don't worry what he could have been, just what he appeared to be, and that's good enough. Miss McKinney, at the moment, Furman, you never know past the moment. There's a thing I've always said too. Even if you get the wrong guy, this guy's done something before, or he's thought about doing something. Now, Your Honor, we believe that in order to assess the credibility of Detective Furman with respect to these issues in terms of his conduct on the morning of June 13th, this evidence must be considered. And you must ask the question whether you would believe this police officer in light of this evidence. And we believe that we're entitled to a finding for our appellate record of your conclusion with respect to the credibility of Detective Furman. And we believe the most rational way for you to make that finding is for you to permit us to call Detective Furman to the witness stand as part of this renewed motion to suppress and engage the most powerful engine that we have to expose the truth, and that is to cross-examine him and confront him with his prior statements to Ms. McKinney.
Thank you, counsel. Ms. Lewis.
Your Honor, first of all, I want to define for the court what the court's role is. First, let's recall that Detective Furman was, and I say let's recall because the court heard a prior 995 with regard to the motion to suppress that was heard in the court below. So the court's already read that transcript of that earlier motion to suppress. Detective Furman was one of two police officers, the other being Detective Van Adder, who testified in the municipal court at that motion to suppress. And that is the factual context in terms of what motion we're talking about that this court looks at. When it came to the litigation of the search warrant, that was done before this court. Detective Philip Van Adder was the affiant on that warrant. His affidavit is what the court looked at to determine the validity of the warrant. Under the law, the court was restricted to, at that point in time, and never had to go beyond that, to the four corners of the affidavit of Detective Philip Van Adder. So when we're talking about Detective Furman's testimony regarding motions to suppress, we are talking only about the testimony that he gave at the motion to suppress, the entry onto Rockingham, brought before the magistrate in the municipal court. Now, as I indicated, when this court reviews newly discovered evidence, and the court has already earlier indicated a finding, and I don't think we're conceding that it's newly discovered evidence. But when the court reviews newly discovered evidence, the court looks to the standard enunciated in the Bishop case, which is briefed in length in our brief on this issue, which is spelled out in length. And the Bishop case mentions several standards in there. What the court does not do is to decide the issue of Detective Furman's credibility. What the court does do is to look to see whether the newly discovered evidence would have affected the finding of the magistrate below. The Ramsey case that counsel cited to the court includes that standard in a footnote where it says this court, Your Honor, can consider the evidence with regard to Detective Furman in a de novo manner only if you determine that that evidence would have affected the magistrate's ruling below. Then you go on to this step, and that's that footnote, dicta in footnote in that case mentions that. But the standard is spelled out very clearly and at great length in the Bishop case. The court was trying to determine what standard to look at to determine when something is affected by, to try and give the trial courts guidance in this area. And the court looked at the idea of relevance. Well, what if it's relevant testimony, relevant evidence? Does that mean it would have affected the standard? And the Bishop court held it couldn't, because that hair trigger type of standard would automatically cause every magistrate's ruling in every motion to suppress brought in the lower court to be affected if mere relevance was the standard. And the whole idea of the legislature in changing this legislation back in 1986, I believe it was to provide the defense one opportunity for de novo review, and only one opportunity, except under very narrow circumstances. And this is one of the potential exceptions that applies when there's newly discovered evidence. But because of the policy of the law to maintain the finality of litigation, the Bishop court holds that there has to be a heightened standard under this situation. And the Bishop court, as this court has noted in a previous hearing, I think it's been many months ago now, looked to the area of new trial motions, looked at the law in that area, and the area of newly discovered evidence, and to see if that standard would be an appropriate one. And it held that that would be an appropriate standard. And I'm going to get back to the new trial motion a little bit later. But I do want to mention, Your Honor, this newly discovered evidence consists of statements that only go in some general manner to bias and credibility, nothing specific in this case, not to any specific person in this case, not to any specific observations or conduct in this case. It only goes somehow generally, in a general manner, to credibility. That, by definition, is collateral evidence. It's collateral evidence on credibility. It's not evidence that has any kind of direct inconsistent statement or direct impeachment of any officer, either of the two officers' testimony in municipal court. And the context in which now let's look at the evidence itself. First of all, we know that it's collateral just by definition because it doesn't have anything to do directly with what was testified to in municipal court. It's only very indirect and by inference upon inference. And then when you look at what the statements are, they're statements that Detective Furman made to a screenwriter. And in that context, and I'm not saying that he was role-playing when he said them. What I am saying is that he was there to impress this woman to write a Hollywood movie. And we all know that Hollywood movies, particularly when they portray bad cops, are vicious, violent, horrible, and depict disgusting things. I mean, that's the whole purpose of a Hollywood movie, particularly when it's depicting bad police officers. You know, you can think of Richard Gere in Internal Affairs went around murdering people. That's Hollywood. That's what it's about. So these statements that he made to Laura McKinney, he was there to impress. There is no trustworthiness whatsoever that anything he actually said is something that he would do, even back then, or that he would do years later after he said those things to her in that context, in this case. So you look at the statements and they're not trustworthy. They're not said in a context that makes them at all trustworthy in terms of his actual state of mind of what he would do 8 years later when it comes to the investigation of this case, during which he played a very narrow role. So you're looking at not only collateral evidence, but evidence that on its face is not trustworthy and probative of even what it would purport to prove or what the defense would have it prove. So when you look at that farly removed evidence in terms of directly rejecting anything testified in municipal court, it becomes self-evident that its probative value is virtually nil. There's almost no probative value there. Now, one of the things the Bishop Court held, and I noticed counsel's lack of addressing the Bishop Court, though it does address this specific issue on newly discovered evidence and a renewed motion to suppress at length. One of the things that court held, the Court of Appeal, is that the implied credibility findings made by the magistrate below had to be as to affected by the new evidence as to both officers who testified. And here that means not only Detective Furman, but Detective Van Adder as well. It's a heightened burden, and that's the language used by the Bishop Court, a heightened burden because this evidence regarding credibility would have to go to both officers. And this evidence, these McKinney tapes and transcripts and anything said by Mark Furman has nothing to do with Detective Philip Van Adder and never has had anything to do with him. He didn't even know Mark Furman before they met that night. So the defense has offered nothing to impeach either directly, indirectly, collaterally, in any manner the testimony that was given by Detective Van Adder extensively during that early motion to suppress, which entirely corroborates every important piece of information testified to by Detective Furman. Detective Van Adder testified to the same things, or to things right in that same nature. I don't mean to say their testimony was identical, but he also testified to the important aspects that were under consideration for that magistrate to consider in that motion to suppress. Now, when you get back to the new trial, the standard of newly discovered evidence, newly discovered witnesses in the context of a motion for new trial, one of what I consider the Bibles in the criminal law is Witkin and Epstein. And Witkin and Epstein say that new evidence calculated merely to discredit a witness at the trial is considered of slight importance, and it is frequently said that it will not support a motion for new trial. So it is rare under the case law that a newly discovered evidence which goes only to credibility is given any kind of deference, and such that a new trial motion is granted. And that's the standard that the Bishop Court of Appeal tells us to look at in whether the court should hold whether or not evidence has affected the magistrate's ruling below in the motion to suppress there. And in fact, in a case cited in my brief in People versus Green, a witness was discovered, newly discovered, who would have impeached the prosecution's main witness, a police officer, regarding that witness's testimony as to the number of investigations he had engaged in and whether he made narcotics arrests for amounts under a certain quantity. So it would have been direct impeachment of that police officer's testimony itself. And the Court of Appeal in People versus Green upheld the trial court's denial of the new trial motion, and held as a general rule, evidence which merely impeaches a witness is not significant enough to make a different result probable. So it's whether a different result was probable. That's the analogy they draw in the new trial motion context to whether it would affect the magistrate. And in different words, make a different result probable there, that the magistrate would have ruled differently. So the Court of Appeal in People versus Green recognized it wouldn't have even made a different result there where it was direct impeachment testimony, let alone here where we have several steps by inferences removed, untrustworthy, but at best collateral impeachment in the terms of affecting credibility impeachment testimony. Now, we also know in this particular case, the magistrate below specifically told Mr. Shapiro when he tried to introduce collateral matter to discredit a witness, she specifically said, the way I see it, Mr. Shapiro, is that if in fact there is an inconsistent statement with something, with regard to something that the detective testified to during the course of the proceeding, then that would be admissible. But we're not going to create straw men to shoot down later that were not part of the testimony. So this own magistrate, to the extent that there's any, and I'm not sure it's appropriate, but if it is appropriate to look at this magistrate's state of mind and whether this particular magistrate's ruling would have been affected, it's pretty clear from that observation of hers that she might have admitted directly impeaching testimony and probably would have admitted directly impeaching testimony, but would not admit collaterally impeaching or collateral evidence regarding credibility. As the Bishop Court itself said, evidence which does not affirmatively prove an issue, but is used only to impeach or contradict an opposing witness, tends to impress weakly. And that's what that Bishop Court itself said with regard to whether it would have affected the magistrate's ruling below in that case. Finally, Your Honor, I want to point out that the people's burden at that motion to suppress was by a preponderance of the evidence. And we had the corroborated testimony of two detectives who testified in detail. All the defenses presented to this court here in terms of newly discovered evidence goes to, as I've mentioned, collateral impeachment, collateral credibility attack on only one of those officers. And I submit, Your Honor, that as a matter of law, that is simply not enough to, quote, legally affect the magistrate's ruling. And that is a term of art, so that there's no confusion. And that's what the Bishop Court has tried to define as a term of art. So there's simply insufficient evidence to show this newly discovered evidence would have affected her ruling because it is collateral and removed from the one officer who it even affects at all in terms of his testimony. It has nothing to do with the other officer. So, Your Honor, the defense is not entitled to yet another hearing in this court of any nature other than the legal argument we've just engaged in, because I believe the appropriate and proper ruling for this court to make is that this evidence would not have, quote, affected, as that term is used in the law, the ruling of the magistrate below.
Do you think, though, that the magistrate would have been interested in hearing cross-examination of Detective Furman being confronted with some of this material on the tapes?
No, Your Honor, I don't. And in fact, I would like to respectfully remind the court, our courts of appeal and Supreme Court, most recently there's a case of People versus Superior Court Piedrahita, Piedrahita, 1995 at 34 Calap 4th 508, that repeats, generally speaking, the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. The cross-examination of the witness is always subject to a trial court's broad discretion to impose reasonable limits to prevent interrogation based on concerns, among other things, harassment, prejudice, confusion of the issues, and that would have happened here, or interrogation that is repetitive or only marginally relevant. So the courts have wide discretion. There's also People versus Cooper, who also cites Davis versus Alaska, which is one of the defense attorney's favorite cases, it seems, to repeat that the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. Most courts, and particularly municipal courts hearing these motions to suppress, along with their preliminary hearings, day in and day out, are not interested in letting the defense go far afield into the netherland in cross-examining witnesses. They want to hear evidence that directly pertains to that witness's testimony and that is relevant and directly relevant to that witness's testimony. So by all indications, this particular magistrate would not have even allowed cross-examination on this issue, let alone have been affected by it.
All right. Thank you, Counsel. I'm sorry, Ms. Lewis, do you want to address one other issue the request at this point to recall based upon this newly discovered evidence, which you concede the tapes are newly discovered since this discovery occurred subsequent to the preliminary hearing and the original 1538.5 motion. What is your position on at least the the defense ability to recall Detective Furman as a witness to confront him with some of these things?
Your Honor, the defense has no such right. This is highly, as I've just argued and pointed out to court, this is highly collateral evidence. Their right was to present to this court the newly discovered evidence. They've done that. This court has read all of the transcripts, I'm sure listened to all of the tapes. I know it's listened to all the tapes, made a detailed, lengthy ruling with regard to the 60-whatever proffers. So this court has heard and has taken in that evidence. It's in the record. It's there. And the defense has no right. And in fact, it would be inappropriate, I believe, for this court to get into any kind of factual determination, which it would be doing if it attempted to hear testimony from Detective Furman. May I have just a moment, Your Honor? As Ms. Clark points out, the statute does not allow for, or does not say that they have the right to confront and cross-examine any witness with regard to this newly discovered evidence. And this is a situation where it's clear, Your Honor, the magistrate below would not have allowed, and as much as I can read her mind, but, you know, having worked in these Muni courts for many years, and this court knows what it's like in Muni courts with the number of felonies prosecuted by this office and the number of witnesses that are called daily and 10 to 15 prelims a day is not unusual downtown. I mean, not only as a legal matter, but in terms of the exercise of these magistrates' discretion, it's very easy to predict that she would have not, because no magistrate below in a municipal court in this building or in any other building probably in LA County would allow the kind of cross-examination the defense seeks to bring on at this point for this court to hear. But I didn't mean to get sidetracked. No, they do not have a right to recall Detective Furman to confront him with this, and it would be inappropriate to do so. The court has the information that it needs, having heard the transcripts and listened to the tapes, to determine if indeed that was even admitted by the magistrate below, which I submit it wouldn't have been. That would have had the legal effect of affecting her prior ruling and causing her to grant the motion. And it simply could not have had that effect when you're talking about two police officers testifying where that evidence affects only one, and the Bishop Court holds that the defense has a heightened burden of it affecting both officers' testimony.
Thank you. Stroman?
Your Honor, having had the benefit of participating in the determination by the magistrate of the motion to suppress in the municipal court, I can assure Your Honor it was not one of 15 or 20 motions being heard on a routine basis. We're talking about a preliminary hearing that went on for more than a week. We are talking about a magistrate who told us how troubled she was by the issues raised in the motion to suppress, and who made some very careful findings, which were largely dependent on the credibility of the testifying officers. That is, she believed the reasons that they offered to justify the actions that they took, and she believed they were reasonable under the circumstances without having the benefit of knowing. What's the matter? Is my zipper open?
No, I was just noticing one of our CCB residents crawling on the table there. Never mind.
Should I kill it?
Got it. Women do kill roaches, Your Honor.
Sorry about that.
The issue before Your Honor, however, is not what effect would this evidence have on the magistrate. And that's the whole point of the Ramsey decision. Where additional evidence is presented, the findings of the magistrate, to the extent they are affected by additional evidence, are not binding on the Superior Court. As the Ramsey Court put it, this allows the Superior Court to exercise its independent judgment on issues on which additional evidence is introduced. So we're not in the position of trying to go back and recreate how Judge Kennedy Powell would have reacted if she had had the opportunity of hearing the Furman tapes in deciding whether she should believe Detective Furman's account of what happened on the morning of June 13th. To the extent that this is newly discovered evidence, the question is, what finding does Your Honor make about the credibility of Detective Furman with respect to the events that took place on the morning of June 13th. And to that extent, the Bishop case relied on by the prosecution is in opposite. They're saying you must challenge the credibility of both officers, but that occurs in a context where the two officers corroborate each other, where you have two officers testifying to the same thing. Of course, just attacking the credibility of one officer isn't going to undercut the factual finding. But with respect to each of the factual issues we have identified, the discovery of the speck on the door of the Bronco, the investigative activity in terms of searching for evidence that took place in the room of Cato Kalin, the searching activity that took place behind the house after Detective Furman decided to follow up on what Kalin told him. Every one of these were judgments or discoveries made by Detective Furman without any corroboration. He was by himself. He was alone. And his credibility stands alone with respect to each of those issues. We're not asking to relitigate everything here. Of course, we're not seeking a hearing de novo on the search made pursuant to the warrant, only to the extent that if the evidence found in the warrantless search supplies the probable cause for the issuance of the warrant, then, of course, the evidence discovered pursuant to the warrant would also have to be suppressed. But what we're talking about here is a warrantless entry to premises. We are talking about the credibility of the decisions and the judgments made by Detective Mark Furman acting alone, and we are asking, what confidence can you have in his credibility with respect to that action that he took, knowing what you now know from the Furman tapes? And the Furman tapes, Your Honor, is in a very good position to make a judgment about whether he was just impressing a screenwriter. We believe the tapes clearly demonstrate he was expressing his own attitudes, he was expressing his own opinions, he was describing his own practices, and those are certainly relevant areas to cross-examine him on before we make a determination of his credibility. And that's an opportunity that was deprived to the defendant because this evidence was not available at the time Detective Furman was confronted in the municipal court. And bear in mind that when Detective Mark Furman testified in the municipal court, he was there to impress a judge. Just as counsel suggests, he was there to impress Ms. McKinney. And the issue that we have to address is whether that was a false impression, whether the conclusions that we draw with respect to the credibility of this witness, of this key witness on this issue, of the suppression of the evidence, can be trusted in light of this newly discovered evidence.
Mr. Owen, let me ask you this, though. What would calling Detective Furman add to the court's record in evaluating the credibility issues that you raise, given the fact that the tapes that the court heard are Detective Furman's voice? I mean, the foundation has been laid either through Ms. McKinney through the 402 hearing or during the course of the trial. We've established that, that is in fact Detective Furman's voice and his statements. Is there anything to be served by calling Detective Furman? What else would you add? Did you say this? Is this your voice? I mean, I can think of 2 or 3 questions we might ask Detective Furman, but...
Well, credibility determinations are based on the entire galaxy of the demeanor of the witness, the factual accuracy of his account. We believe that everything we have pointed to in the Furman tapes goes directly to issues that he talked about in his testimony and that raised questions about what he was saying.
Well, what would be your offer at this point, given the fact that the court has, with regards to previous rulings, reviewed the transcript of the preliminary hearing? With regards to prior motions regarding the McKinney matters, the court has read the transcripts, listened to the tapes. I did sit through, my recollection, it was approximately 5 or 6 days of testimony by Detective Furman during the course of this trial. What more can we add to the record? What more do you think would be needed to add to the record for the court at this point to evaluate all these things anew? And I agree with the point that you make, that based upon the showing of newly discovered evidence, which was not available, not reasonably available at the time of the preliminary hearing, that the magistrate's finding is not binding upon this court, and that this court, upon appropriate motion which you've made, is required to go back and reassess what's here. But you're asking, in addition to that, asking to recall Detective Furman, and I'm just asking for an offer of proof as to what line of questions you would venture into that would add to the court's store of knowledge with regards to Detective Furman.
We would confront Detective Furman with each of these key accounts or justifications that he offered for his conduct on the morning of June 13th, and we would question him as to whether on prior occasions he has indicated that he doesn't play by the rules, that he makes the rules up later, that he doesn't really care what the courts say about what officers can do and can't do.
In other words, you would go through each one of the 61 incidents that you put forth in your offer of proof with regards to the offer regarding Ms. McKinney.
No, Your Honor. We've submitted a new offer of proof just related to this, which lays out, I believe, 7 excerpts from the transcript that we believe are relevant just to the issue of probable cause. We're not trying to open up racial attitudes. We're not trying to open up the whole spectrum of police misconduct that was raised in the McKinney motion. We've tried to focus this right on the issue of probable cause and justification for police conduct in which he engaged. And I know Your Honor has heard Detective Furman testify, but I really would ask you whether you would hear his testimony with the same ears today, knowing what you have heard on those tapes. And
it's not just knowing what I know on those tapes, it's what I heard from Ms. Singer, it's what I know from Ms. Bell, and what I heard from Mr. Hodge.
And that, too, is all newly discovered evidence, Your Honor. The fact that Detective Furman has perjured himself in this trial, we believe, is relevant to the credibility that we give to the testimony at the motion to suppress. I dare say that in any case being tried in these courtrooms, if in the course of the trial a court were convinced that an LAPD officer had come into the courtroom and committed perjury, the court would not hesitate to go back and reevaluate and re-examine the testimony that was presented in the pretrial motions. In fact, we have inquiries going on right now where on the basis of the discovery of forged evidence, we're going back to cases that were tried years ago to get to the bottom of it, to get to the truth of it. And that's precisely what we propose to do here.
All right, given that offer, what do you think the likelihood is that former Detective Furman would be available to testify?
There's only one way to find out, Your Honor. Let's bring him in, put him on the witness stand, and put the questions to him.
All right, thank you, counsel.
Could I have just a moment?
Sure.
May I?
Why don't you wait until Mr. Baldwin finishes talking to Mr. Neufeld.
I'm in debt to Mr. Neufeld. To the extent that the people are arguing that there is any question about the context of what is said in those tapes, that is, whether he is speaking his own mind, whether he is puffing, whether he's trying to impress Miss McKinney, the way to determine that is by questioning and cross-examining him.
All right, Ms. Lewis.
Your Honor, the concern here, of course, is that Detective Furman is not himself in the same position that he was down at the municipal court below. There was no, there had been no testimony with regard to the N-word. There had been, that's totally irrelevant to this proceeding, this hearing. But Detective Furman now finds himself in a position because of that. And because of the, it's clear there's been an outcry in the city, Your Honor, and perhaps appropriately so. But as we've stressed over and over again, that is for another forum, another place, another time. To box this court into calling Detective Furman, making him have to make the difficult decision of whether or not to take the Fifth Amendment, creates additional complexity and adds issues and misleads. Well, it doesn't mislead, but it consumes time, takes away from the sequestered jury we have in this case, adds nothing to this court's knowledge with regard to what it needs to know to determine if this evidence would have affected the prior magistrate's ruling. It does not, it is certainly within the court's discretion to deny any such motion, and I think as a matter of law, it's inappropriate to even entertain such a motion by the defense. And in addition, as Ms. Clark points out, even if it were true that that's how he felt back in 1985, there's no proof that that's how he feels now or felt in 1994. You know, this was a man who, well, I don't want to get into the history. The court, heard evidence in context of the Pitchess motion, but people change over time. This man became married, had 2 children. You know, I don't want to get here into a personal defense of Mark Furman. That's not why I'm here, Your Honor, and I don't want to do that. What I do want to do is point out to the court that this is collateral evidence that does not go to directly impeach him, and that there are 2 officers who testified. And for this court to get sidetracked off into a side issue of whether Mark Furman is going to take the Fifth Amendment is not appropriate, not in this context, especially when we're talking about the renewal of their motion to suppress. The court, as it's just explained, has all of the evidence it needs. It has this very complete. There's no such thing as very. The record is complete, and that means one thing. It is complete in terms of what this court needs to assess whether or not it would have affected the ruling of the magistrate below under the circumstances of that case. And this court is not, I submit, entitled to this defense argument of the perjury, whether or not perjury was committed here in this case, in assessing whether it would have affected the magistrate below. And, Your Honor, whether the defense offers 7 excerpts from their new proffer or the 60 or 70 that they offer below, the law is the same in this regard. The court has heard all of those. The court has read the ones that, all of them, plus the ones that were not available to hear on tape. So the court already is intimately familiar with it. It's time for the court to have to make the difficult decision and to have to struggle with making a ruling on this case. But that's not going to be, that burden is not going to be lightened and would just be dragged out, and likely the court's, the complexity of the ruling would be magnified by having additional unknown factor thrown in at this point in time, Your Honor.
But if I don't do that, don't I have an incomplete record?
Oh, absolutely not, Your Honor. Please. I mean, the court can see that this is collateral evidence. It does not and never had to allow cross-examination on this evidence at all. The defense in the new proffer is talking about misconduct things. They recognize it's apparently, because they left it out. They don't even leave out the N-word stuff. I mean, the court has heard all this stuff. The court has heard the context in which it was played. The court, and in fact, if Detective Furman gets up here and takes the Fifth, the court, I think the state of the law would be the court cannot consider him having taken the Fifth in terms of deciding the earlier ruling, because the jury is not allowed to hear that somebody took the Fifth, and I'm sure the same law would apply, that the court could not consider that fact because you'd be impinging on his right against self-incrimination. It gets unduly complicated, Your Honor, and it's not necessary. The record is complete. I know you as a very thorough, meticulously thorough judge, but I'm telling you, Your Honor, as a meticulous and thorough attorney, this record is complete on this issue.
All right, thank you, counsel. Mr. Munger, Mr. Darrell Munger is also here with us. counsel for Mr. Furman. Good afternoon, counsel.
Good afternoon, Your Honor.
You've been present for our discussion regarding the defense motion to, based upon newly discovered evidence, to revisit the motion to suppress. And one of the key issues is whether or not the court would allow your client to be recalled as a witness for additional testimony. Do you have any observations regarding that?
Well, before I answer that question, may I be allowed to speak briefly about the motion?
Well, I think the issue is whether or not your client is available to testify.
Well, Your Honor, first I would ask that, similar to the issue when Mr. Kardashian was asked to be a witness, because of the position that Detective Furman is in, I would first like to see, if the court could allow it, the questions, the exact questions that they plan on asking him. Because asking him to testify at this point in time may have a difference depending upon the questions that are asked.
All right, Mr. Allman, do you have an additional copy of your specific offer proof regarding this issue available?
I'm sure we can have a copy duplicated, but we don't believe a witness is entitled to a preview of the questions that they're going to be asked on cross-examination. The whole purpose of cross-examination is to test the credibility of the witness in reacting to questions as they are put.
Well, at this point, counsel, since, I mean, that offer of proof is not under seal, it's not exactly a mystery as to what it is we're talking about here. We've discussed it here in open court just now.
Yes, well, I'm sure we can simply duplicate the copy we have available.
All right. Well, in any event, I need to give the court reporter a brief recess, so we'll take a brief recess. Counsel, if you'll provide Mr. Munger with a copy of that, he can peruse that, and we'll discuss it, continue this discussion in about 15 or 20 minutes.
Thank you, Your Honor.
All right. Thank you, counsel.
Please clear the courtroom.
Where did Mr. Shapiro and Mr. Cochran disappear to? All right, back on the record in the Simpson matter. All parties are again present, including counsel Kent Spaulding. Court has acted upon the application pro hoc vice and approved that. Good afternoon, counsel. All right. During the brief recess, counsel had the opportunity to informally discuss scheduling matters, and based upon the Brady issue that the court still needs to deal with this afternoon. Mr. Cochran.
I had indicated to the court that with regard to the Brady, Messrs. Scheck and Shapiro, along with Ms. Sean Snyder-Chapman, will be down at 4 o'clock. They're in the process of interviewing witnesses. They did indicate to me that they may not be ready to proceed completely today on that, and may ask to start that tomorrow morning. And I told them to come by 4 o'clock so they could let the court know that. That's the only holdup that what we talked about earlier.
All right, and I see Mr. Munger stepped out briefly.
Your Honor, may I take this opportunity very briefly just to mention something that I neglected? It's my fault. I neglected to mention to the court earlier.
No, I don't think so, Ms. Lewis. You've filed your points and authorities. I've heard rather
There
extensive
was a
argument.
supplemental memorandum filed by the defense yesterday afternoon after they'd already filed their two other memos in the same thing that I did not pay careful attention to, so just briefly for the record, please. Please, I can see we have time. We're waiting for Mr. Munger. Very quickly. Very quickly. It might help the court.
The
in this
moment he
ruling.
walks in the door.
Thank you, Your Honor. First of all, on page number 4 of their defense...
But then I have to listen to Mr. Ullman as well.
Okay. Offer of proof of newly discovered evidence for motion to suppress. They have 3 things, very briefly, Your Honor. The first thing is that they say the decision to make entry by climbing the wall. Detective Furman was the D2. We know that the others out there were all D3s.
Counsel, I recollect the testimony.
I'm sure it was their decision. The second offer had to do with Mark Furman searching Cato's room, but their cross-examination of Mark Furman would add nothing to Mark Furman's credibility on that because Cato testified at the preliminary hearing during the motion to suppress and testified to the thumbs.
He gave consent to the search. Next
Yes,
question.
and also indicating the thumbs on the wall. So that makes Detective Furman's testimony that Cato told him he did thumps on the wall. I mean, there's no credibility issue there whatsoever. And the third one was that given the statements that Cato made to Detective Furman, which we know were made, that was obviously why Detective Furman went behind the walkway. So how is the defense going to hurt his credibility in terms of why he went to the walkway when we know Cato testified during the preliminary hearing as to those 3 thumps behind there? That's all I wanted to say, Your Honor. I just wanted to point out that their intended cross-examination would not shed light on the issues they list in this supplemental brief.
All right. Thank you, counsel. Mr. Ullman, do you feel compelled to respond to that?
No, Your Honor.
All right. Thank you. All right, we've been rejoined now by Counsel Darrell Munger, who represents Mark Furman. Good afternoon again, Counsel.
Your Honor, over the break, I talked to Mr. Furman, and it is our position that because I am walking into this trial after 8 months, I am unfamiliar with all of the testimony. I have been handling my own cases and not followed this trial intimately. I have come into this court asking for the McKinney tapes and a copy of the transcript so that I might review them with my client. Although I have reviewed most of them, I've tried to correlate that information and interview my client, and I'm unable to put it in the context which it deserves. Based upon this court's August 31st ruling, and the words specifically, I believe, on page 5, on the information I do know, and the information especially I do not know, I have advised Mr. Furman that he should not answer any questions before this court. Therefore, it is my understanding that he will assert his Fifth Amendment privilege if asked any questions.
All right. Mr. Ullman, for the purposes of the record, will you accept that representation?
No, Your Honor, we believe it's necessary for him to assert the privilege from the witness stand in response to a question.
All right. Since there's an unwillingness to accept and stipulate to that, it'll be necessary for Mr. Furman to resume the witness stand for the purpose of this motion and to assert the privilege.
He will be here shortly, Your Honor.
All right. All right, then, Mr. Ullman, Ms. Lewis, I've indicated to you off the record that I need to, in order to rule on the motion to suppress, the renewed motion to suppress, I need to review the preliminary hearing transcript, which I have not had the opportunity to do since much earlier in the trial. So I'll need to do that. So I don't think you should anticipate a ruling this afternoon on that motion. And Mr. Cochran, I did see Ms. Chapman come in. There she is. Did she give you a status report?
Check, and may I confirm too, they have it. I'm informed by Mr. Scheck and Ms. Sean Snyder-Chapman that they're in the process of interviewing witnesses, that they will take the rest of the day to try and do that. They cannot finish, they think, until tomorrow morning in that regard. They're asking that we come back tomorrow at 10 o'clock and they'll be ready to proceed with the Brady motion. They're going to have these witnesses brought down shortly with Mr. Shapiro, I believe, along with Mr. Yokelson, to ask that they be ordered back, finish today and then ordered back for tomorrow morning. It's my understanding of what Mr. Scheck indicated. And we'll start again at 8:30 tomorrow morning after they finish today.
I'm sorry, I heard 8:30 and I heard 10 o'clock.
Yeah, 8:30. They're going to try to finish the interviewing the witnesses this afternoon. In case they can't, they want to resume the interview tomorrow morning at 8:30. And they say, given that,
How about we finish the interviews tonight and start tomorrow morning at our regular 9 o'clock?
I'm sure they're going to try to do that, Your Honor, but out of an abundance of precaution, their thought was there are a number of witnesses they would perhaps need until 10 and have the witnesses ordered back tomorrow for 8:30. I think that was the plan. They are trying, Your Honor. We had them go do that this afternoon.
How many witnesses are we?
Let me let one of them speak.
All right, Ms. Chapman.
Good afternoon, Your Honor.
Good afternoon.
I know that Officer Detective Maxwell was going to leave by 4 o'clock today to try to pick up a child from school. So I don't know that we'll be able to interview him this evening. Mr. Yokelson will be down with the rest of the witnesses, and we'll try to interview whomever we can this afternoon.
But how about if we come back at 9 o'clock, and if we then at that point can't?
Okay. Okay.
All right. Thank you.
So the record is clear. The defense has had 6 months to talk to these people. They interviewed Lucianne Coleman
Excuse me,
in
counsel.
April.
Ms. Clark.
They interviewed Ms. Coleman in April. That means that as of this date, we have more than 4 months that they have had to talk to these witnesses, and now we need extra time at the 11th hour for them to interview witnesses they've had access to, opportunity to talk to ad nauseum for more than 4 months, and in some instances 6 months.
Which is why I'm inclined to resume tomorrow morning at 9 o'clock at our regular time. There are other motions we do need to conclude, however, at this point in time.
And can we get a representation on the record as to what other witnesses the defense intends to call, other than the Brady witnesses, quote unquote, and I use the term loosely, that they intend to call before the jury?
I think part depends on the court's ruling on the 1538.
How would that be? Assume the court grants it. What further witnesses would they need to call?
I don't know. I don't have. Mr. Cochran, who else do you have after, since we've finished Mr. Hodge and the court's ruling, we're finished with Ms. McKinney?
Part of it is, Your Honor, that there are 2 witnesses, as the court is aware, that I mentioned Mr. Petrino and Mr. Goldston, who are upstairs. I presume they're going to be talked to. I haven't gotten a report on those 2 at this point. We would also like, so we don't have any downtime, I've indicated this to counsel earlier, to know who their first rebuttal witnesses are so we can prepare for those. Otherwise, we have downtime on that also.
All right, so your representation is Goulston and Petrino based upon the interviews that you conduct this afternoon.
And Furman, if the court is aware of that, and then plus the Brady motion.
All right. All right, thank you, counsel.
Thank you. We're going to need the rebuttal witnesses also, Your Honor.
As soon as the defense rests.
All right, Mr. Allman, I take it at this point then you wish to recall Detective Furman?
Yes, Your Honor.
All right, and so the record is clear. My recollection is that Detective Furman, who is now present in court with counsel, Mr. Munger, my recollection is that Detective Furman was excused but not released and was subject to recall. Is that your recollection?
That is correct, Your Honor.
All right.
He was not excused.
Well, let me rephrase that. Subject to recall, excused for the day, subject to recall, not terminated as a witness before the
That's
court.
correct.
All right. All right, and Mr. Munger, if you wish to stand next to your client, you may. All right, Detective Furman, would you resume the witness stand, please? All right, good afternoon, Detective.
Good
Good afternoon, Your Honor.
You're reminded, sir, that you are still under oath. Mr. Ullman, you may proceed.
Detective Furman, was the testimony that you gave at the preliminary hearing in this case completely truthful?
I wish to assert my Fifth Amendment privilege.
Have you ever falsified a police report?
I wish to assert my Fifth Amendment privilege.
Is it your intention to assert your Fifth Amendment privilege with respect to all questions that I ask you?
Yes.
Could I have a moment?
Certainly.
Your Honor, further questions don't serve any purpose since my client has already answered that he will not answer any question and will assert his Fifth Amendment privilege. Anything further can only be a show.
I only have one other question, Your Honor.
What was that, Mr. Ullman?
Detective Furman, did you plant or manufacture any evidence in this case?
I assert my Fifth Amendment privilege.
All right, based upon the witness's answers, the representation by his counsel, Mr. Munger.
Your Honor, people make an objection to the last question asked the court to strike it as improper and done for nothing but headlines.
Or will the answer will stand. All right. Ms. Clark, do you have any questions of this witness? All right. Then, given the assertion of the Fifth Amendment privilege, we will not conduct any further inquiry as to Detective Furman. But however, Detective, I am going to release you from further attendance this afternoon. However, you are still subject to recall. All right. Thank you, sir.
Thank you, Your Honor.
If the defense intends to recall Detective Furman for the purpose of having him assert the Fifth again, I suggest that we do it now. Why have him come back for that purpose and not permitted to do it in the presence of the jury?
No, counsel, I just want to make sure we preserve the jurisdiction of the court in case there are any other issues that come up.
I understand that, but what I'm saying is, will this assertion suffice for the trial testimony as well? I can see no purpose to be served other than a further waste of time to have Detective Furman recalled to reassert the Fifth Amendment privilege again. And I'm asking that if counsel intends to do so, that we allow that record to be made at this time.
Record's been made at this point.
For the purpose of trial testimony as well?
Based upon the representations of counsel that he's not going to answer any further questions regarding this case.
Your Honor, since he lives without the state, is he free to travel home?
He's-
May we, next court approach, allow us to approach him.
Sure. All right, with Mr. Munger, please.
We have one witness who is in court, Detective Andrew Purdy, who is present with his counsel. I'd like him back for tomorrow.
All right, counsel, your name for the record?
William J. Haddon, Your Honor.
All right. Mr. Haddon, you and Mr. Purdy ordered back tomorrow morning, 8:30.
Thank you.
All right, thank you. You're excused.
Your Honor, we have 3 members of the District Attorney's Office we'd like to have for testimony tomorrow that we've informed Mr. Hodgman of. We need not give their names tonight. And we have several other officers that Mr. Hodgman has been kind enough to accommodate us with, but we have not had time to interview. And we would like to give you that list, but not in open court. We have no other witnesses in court. Is that correct, Mr. Hodgman? Yes. Well, we would like to give you that list, and Mr.
All right,
Hodgman,
what's
I'm
your
sure will
time
make
estimate for your Brady motion?
Your Honor, we are still in the process of interviewing some of the witnesses. Mr. Purdy has been very, very cooperative. We have about another half hour with him, and we'd like to interview the remainder of the witnesses tonight. I'd be in a better position to give you that estimate tomorrow morning when Mr. Scheck, Ms. Chapman, and I have had a chance to assimilate all the material.
All right. So what advice do you give the court on the question that weighs most heavily on my mind?
I would say that certainly no earlier than 10 o'clock, Your Honor. I think by that time...
I'm getting advice. All right, Ms. Clark, what's your position?
I think I made it pretty clear. They've had 6 months to talk to these people, and now they want more time. This is another delay with this jury on ice again. That's so unnecessary. And has the court pondered?
No, I'm just asking, do you have any estimate as to how long you think the hearing will take based upon what you know from the moving papers, who the witnesses are, and what the issues are posed? I mean, do you just have a guess? I'm just inviting you to help me a little so we can not keep the jurors too inconvenienced for too long.
Well, there's no testimony necessary on the motion, Your Honor. Counsel can make their pitch to the court. The bottom line issue of this, I think, comes back to what the defense likes to characterize as a log, and that's of Officer Purdy, and that's it. There is very little else to talk about, but it certainly does not require the testimony of witnesses. And if this hearing is conducted in that fashion, which is all that is required, then it should be done in about half an hour. Because there is no exculpatory information that has not been turned over, Judge. You know, the people in this matter turned over everything that came to them back in February, as the court knows, submitted it to the court for examination, for IAD investigation, all of which was turned over to the court back in February of this year. So at this point, you know, the people have satisfied their obligations. There's nothing that we haven't done. And the court should be able to make that finding in about 2 minutes.
All right, I'll guess an hour then.
For the court's edification, ordinarily, the facts would not be in dispute when we're dealing with deputy district attorneys and members of the Los Angeles Police Department. However, we're in a paradoxical situation here where we have certain statements, and one under penalty of a declaration that's been filed that has not been signed, that indicates a certain set of facts from at least one and possibly 2 deputy district attorneys, and a statement that we understand was given under oath in internal affairs saying that the deputy district attorney was a liar from one of the members of the Los Angeles Police Department. If we could get a resolution of the facts with the help of the district attorney's office, that would certainly move this proceeding along.
All right. Thank you.
And remind the court that it asked counsel to bring in their reports and notes to assist the court in determining what stage they were at, and I think the court asked them to do it last week. Was that turned over?
Yes. Yes, it was.
The people have
All right.
not been furnished with any of that.
10 o'clock.
Thank you.
With the jury. All right, anything else? All right, we're in recess.